Sorry for keeping you waiting.
My lord, I'm moving a matter for 7th.
Yes, from here.
Okay.
Yes.
My lords, with my lords, kind leave, my lords. I'm filing a memo, my lords, with regard to writ of mandamus, my lords, to consider the application for quarrying license, my lords, on survey number 189, my lords, the forest,
What is the urgency? Please tell the
my
urgency,
lords, the
sir.
application is not being considered on account of it being.
Then it will
listed.
come in the regular, court to
contrary to
cure
the
all
law.
the defects.
Once the defects are removed, it will be listed. Yes.
Contempt matter, fresh
Need
matter.
not give the memo.
Fresh matter for.
You remove the office objection.
Complaint.
My lords, it's
Then
compliant,
it will
my
come within 5 days.
No, what happened, it was listed for non-compliance before this court, my lord. Direction to comply, I've complied already, my lord. Unfortunately.
It will come automatically.
my lord, proof, it was order to be listed on 2nd of April, my lord. That's the reason, urgency. That's the reason.
List it, list. We
lords,
list.
all office.
Yes.
objections-
My lord, arbitrator's order.
Don't take any memo. It will
Lord,
be
with
listed.
respect to the existence of
It will be
arbitration.
listed, mister. Once you comply with the office objections, it will be listed.
Lord, with respect to existence of arbitration clause, is being directed to be decided by the arbitrator. Arbitrator has decided even though there was no arbitration clause. I'm filing this 227 writ petition on the sole ground that lack of inherent jurisdiction on the part of the arbitrator.
It will be listed.
Matter is set down for evidence on 11th. I'm requesting it on to be listed at lordship convenience. on
Hold
11th.
or fresh matter,
Fresh matter, 7th month.
it will be listed within 10 days. Within 10 days.
Matter is on 7th.
7 days.
It will not happen. It will not make any difference. Within 10 days. Yes.
My lord, this matter listed on 27/11/2023, my lord. After issuance of contempt notice, my lord, the pensionary benefits has not been settled of the complainants, my lord.
Within
Complaints
15,
after
within
it-
15 days, we will list it. Yes.
I'm the owner, my lord. The respondent has put up my owner, respondent put up saying my social property, my lord. Therefore, there is a urgency, my lord.
Not able to be.
The respondent put up construction in his property.
My scheduled property, my lordship. Therefore, it is six.
Fresh matter
Fresh matter, my lordship.
within 10 days.
My lordship.
Your lordship,
But subject to removal of office objection.
Already removed, my lordship.
Unless they are removed, it will not list it.
Yes, my lord, already complaints, my lordship.
your lordship, this is a writ appeal. The appellant here is the employer who has challenging the writ petition order wherein the employee has been reinstated into the position. However, there's also a consequential benefit of promotion being considered. Now, we cannot consider the promotion of the respondent herein.
The promotion can wait.
Yes, your lordship, we are apprehending that contempt petitions may be initiated as the writ petition orders us to consider promotion.
It will
Hence,
come
there is urgency.
in regular course within 3 weeks. Within 3 weeks.
My lords,
All office objections have been complied with.
Then it will come on 5th
Then
day,
why
madam.
don't you,
No need to
why you
move
are
the memo.
mentioning that if all are complied with?
Because we are apprehending that contempt proceedings may be initiated.
No urgency.
my lords,
Within 3 weeks.
my lords, I am filing, this is a writ appeal, my lords, wherein 4 weeks were given to comply office objections, my lord. The office objections have been complied and it's order. I have filed the IA for order for recalling, my lords.
No urgency. Yes.
My lord, I'm appealing for the respondent. I'm a tenant in a co-working space. The appellant here and they've cut the air conditioning and they're not providing clean drinking water and basic hygiene is not being maintained. My lord, the urgency is that breathing in the premises has become a difficulty, Your Honor. My lord, it may kindly be posted for tomorrow.
Within 1 week.
My lord, kindly for tomorrow.
Within 1 week, you will be listed. Subject to your removal of.
My lords,
My lord, I'm appealing for the respondent.
You give the notice to the other side first.
Then inform the other side.
Please, ma'am.
my lords, this is.
So mentioning or submission of memo by the respondent without informing the other side will not be permitted.
Please.
Because somebody will again come and seek time on the ground that they are not knowing about the posting of the matter, right? So inform, yes.
This is a commercial appeal. This honorable court had already granted an interim order restraining the respondents from interfering with my peaceful possession on February 22nd. However, they've still not complied with the order and they're interfering with my development process, my lords. Therefore, I filed an IA for police protection. It may be considered, my
It will come not in regular course, but after 4 weeks, within 4 weeks.
My lords, the interfering with the peaceful possession, it will render the interim order infructuous, my lords. That is the only reason, my lords.
What is the interim order?
Interim order is the ex parte ad interim order not to interfere with my peaceful possession. And I'm constructing on the scheduled property, my
So you are
lords.
putting up the construction.
Yes, my
No urgency. You hold for some time. Next.
My lord, this is a writ appeal, my lord. A grant was made in my favor and that was challenged before the honorable court. The court has not set aside the grant, but it has subject the grant to the satisfaction of the petitioner therein. And hence, my lord, it's a pending matter. The urgency happens to be that the honorable single judge has observed that there is extra land that can be given to the petitioners in the same survey number, but has also subjected the grant in my favor to the satisfaction of the petitioners, my lord. And hence there's urgency because I'm not able to use my grant for any purpose, my lord, and we are class.
With the urgency, there is no urgency. Let
urgency.
it come in the regular course.
Your lordship,
Anytime, even a month.
Please
later, my lord.
understand what is the meaning of the urgency and then make your submission.
your lordship, this is a contempt petition. An interim order was granted in our,
Concerning another matter.
yes. An interim order was granted in the petitioner's favor, stating that the respondent should not interfere with the functioning of the bank account. However, they have marked lien on the bank account and they're not allowing any transactions. Now, the partnership business is suffering because no vendor payments, sub-vendor payments are able to happen.
Within 10 days.
Then,
Your Lordships, this is the contempt petition. The Honorable Court had directed the respondents to comply with its order in the previous writ petition which you had filed within 3 months. It's been almost a year. There's been no the respondents have not come.
Of the family court. Interim orders of the family court.
No, Your Lordships, it's implementation of the RERA orders.
There are. Real estate operator.
Your Lordship, with your kind leave, your Lordship. Appearing for the respondent board in serial number 49, your Lordship.
Yes.
I appeal for the petitioner in this.
I've informed the opposite side, your Lordship. In this matter, I seek a small accommodation, your Lordship. The arguing counsel is not available today on
Serial
some
number?
person. 49, your Lordship.
49.
Appearing for the respondent number 1 board, your
I
Lordship.
appeal for the petitioner, my lords. No objection. The interim order may kindly be extended, my lords. As an interim
Be
order.
extended. So at the request of learned advocate, Miss so and so, so and so.
Respondent advocate seeking time.
He is he is the respondent.
Respondent. He is for.
Respondent number 1 board, your Lordship.
What's your good name, madam?
Krishika Vaishnav, your Lordship.
Send out which date? Which date do you want?
Any date convenient, your Lordship.
Let it go to
18th, my lords.
20th March. Interim leave granted earlier shall continue to operate till the next date.
Grateful.
A copy of the
Grateful.
petition is not served on.
Yes.
Copy is not served on us.
So copy.
It is 14%.
Any adjournments? Kind permission. Still number 1,
GS submission not modified. Copy not served. Counsel for the applicant.
All other
Set up
GS?
copy to the government.
Please.
Please, your Lordship.
Done?
Memos. Seeking 3 weeks time was only because she was in maternity leave, and secondly, I need to take instruction from the Supreme Court Council because we have challenged the order. The
Lord,
cases
no.
are pending in the Supreme Court. These are the new set of.
My lord, my humble submission is this, my lord. SLP has been dismissed and furnished as an annexure to the contempt petition. Review petition before this honorable court is also dismissed. They have withdrawn. Few. 4 matters are
One is
connected.
withdrawn, 3 is not withdrawn, your Lordship.
Now
We
they
have
are-
challenged that in this.
My lord, SLP order is also have produced, man.
They are complying with
Please.
within 3 weeks.
3
copy
weeks.
make-
Learned advocate with so and so, so and so. For
Madam.
the accused,
Compliance.
you call it accused, no?
Please.
Accused
Accused.
Accused.
Number 1 and 2.
submits the memo indicating that the orders under contempt shall be complied with within 3 weeks. The memo reads as under,
Therefore.
so quote the memo. In view of the above, the contempt proceedings are closed. The respondent accused shall abide by the undertaken given to the court.
My lord, liberty may kindly be given to me to seek the permission to revive the same man.
The failure on part of the respondent
Please,
to
man, please, kindly, man.
comply with the
Copy.
commitment will expose them
Copy
to
of the memo.
Copy, I
please
will, I
serve
will,
in-
I will.
contempt
serve.
jurisdiction again.
Please, both the matters are same.
Both the men.
Much obliged.
Separate order, but same order.
Please, man.
still number 3, Mr. Joseph Anthony, My lord, I appear for the first respondent.
My lord, this petition has been preferred, my lord, owing to the lack of uniformity pertaining to the Ownership of Flats Act, my lord. My lord, there are two, as my lordships are aware, there are two acts. As my lordships are aware, my lord, there are two acts pertaining to apartment ownership in the state, my lord. One is Karnataka Apartment Ownership Act and the other one is Karnataka Ownership of Flats Act, and both are enacted in the year 1972, my lord. Now, my lord, there is a lot of overlapping between these two acts, which has prompted the petitioners to prefer the instant PIL, my lord, because I am unable to register an association. Now, what happens is that, my lord, there is a competent authority under one act. That is the Registrar of Cooperative Society. If I approach the Registrar of Cooperative Society under that act, he says you have to conform to the other act. So there is a lot of lacunae, my lord, which has prompted me to approach this court. And my lord, as the petition was pending, even the state government had come up with a proposal that they would come with a uniform act to address these issues. My lord, if that is coming for, this petition can be disposed of with those guidelines, my lord, because may I just
You
pass?
just file a memo mentioning the same and withdraw the writ petition.
No, my lord, unless, because this has been in the fray, but they are not coming up with it. Until then, there is a vacuum, my lord, because another thing what I would like to bring my lordship's attention is a similar issue on the locus standi of an association was questioned before the Honorable Supreme Court, my lord. In that also, the Honorable Supreme Court holds that the associations had no legal standing despite it being governed under one act, my lord. So there is a lacuna, my lord, admittedly.
So you are registered, who are you? Individual.
I am an individual. I am also an apartment owner who had even headed an apartment
So
ownership.
there is nothing specific in this. Any specific instances
No, my-
arises, you can go to the authority and make representation.
My lord, in the grounds I have culled out, what has prompted me to approach this court, my lord?
On general things, we don't entertain the public interest.
My lord, I am espousing a larger cause here, my lord. My lord, my earnest submission would be, my lord, in view of the state government proposing that there will be a uniform law, the petition may kindly be disposed of, my lord.
We
with
do
those-
not know who is, we are proposing something.
I have, in fact,
He has brought, he just showed me a newspaper cutting where the deputy.
the deputy CM himself has made that thing, my lord. It's a,
I'm taken by surprise with these submissions.
my lord, if the deputy CM makes a submission, I mean, I don't know why the state government would be taken by surprise.
Gave a statement, he didn't.
Court
make
never
any
relies on the
submission.
newspaper cutting.
I bow down to that, my lord, but this is what is available on the public fora.
Sorry, heard learned advocate Mr.
Joseph Anthony, my lord.
Joseph Anthony for the petitioner, this paragraph, the present is a writ petition in the style of public interest petition, whereby a writ of mandamus is prayed for against respondent 1 and 2.
Then I may be permitted to withdraw it, my lord. I'll make a fresh petition on the basis of.
Joseph Anthony seeks permission to withdraw the present petitions. Disposed of accordingly.
Please, my lord. I'll file a memo to that.
Non-compliance of office objections.
So this compliance office objection up to 24,
Appearing for appellant.
up to 24, 3 weeks, 25 and 26, 2 weeks.
Serial number 11, my lord, wherein it has complied, my lord.
11 is complied with,
Yes, ma'am. They have complied.
they have complied with.
Yes, ma'am.
So you are Satish Bihar.
Pawan Chand is 12, man.
Number 12.
12.
My lord,
Sorry,
item,
13.
item 12, my lord, I am for the petitioner.
Yes,
My lord.
By complaints.
In item number 12, my lord,
Government.
yes.
in item number 12, I am for the petitioner. There is a deliberate non-compliance violation of the order dated 1st August 2023, my lord. The respondents were directed to release the amount forthwith, my lord.
So which number, sir?
Sir,
Item number 12, my lord. Item number 12. Need equal versus the Commissioner of
So
so-and-so.
what do you want about 12?
No.
Well, my lord,
Mine is,
Sorry. Your matter?
no.
deliberate violation, my lord. This is contempt, my lord, the contempt petition of order dated 1st
They
August.
are it is listed for office objection, Mr. Counsel.
There are 11 objections as
Nothing,
you
my
are
lord,
gave out to
because-
complain.
Because all commissioners are the parties and the state is the formal party.
Whatever it is, you do within 2 weeks. Yes, yes. Same.
My lord,
Serial
My
number
lord,
13, my lord.
that can be
13.
overruled, my lord.
Complied.
State
Learned Advocate Mr. Pawan Chandra Shetty states that the order under contempt is complied, directions under contempt are complied with, directions brought under contempt are complied with. Accordingly, the application does not survive,
Survive and it is
Complied.
considered as infractions.
accordingly disposed. Yes.
Yes.
So 20,
Number 27 for orders.
what about 26? Yes, 26, 2 weeks, yes.
Number 27.
My lord, there was a direction for me to comply with the order dated 3/3/20, my lord, where I had to make a submission to my lord with regard to the, my lord, the action taken pursuant to the report. My lord, may I seek for 2 weeks' time, my lord, to inform my lord about what has happened subsequent to the submission of the report.
Learned Government Advocate seeks time to take instructions in light of the order which was passed on 3/3/2020 by the court.
Obliged, my lord.
Send over to 21st March.
How many, yes, how many weeks, madam?
2 weeks, my lord, is
21st March.
21st, my lord. Obliged.
Grateful, man.
Number 28.
That is this, my lord, I filed
That
memo for
matter-
retirement, my lord. I'm for backward class commission minutes, I filed memo for retirement in 2 writ petitions. I may be permitted to withdraw.
Madam, madam.
Yes, 28.1 and 20.
I mean, permitted to retire.
Please, madam.
Take up in the next week.
Please, madam.
The one of the matter is till 39.
My lord,
You have to file reply.
my lord, I have filed the affidavit, my lord.
So we'll take
We'll
it
serve a copy week after next, my lord.
after a week.
Please.
My lord, may, with the due apologies for the interruption, let till then, let the things be not precipitated and
Without hearing at length all the councils, we are not going to pass anymore. We wanted your apprehension or your submission was taken care of by directing them to file. What is the affidavit? It is
My lord,
submitted.
the affidavit is, my lord, that a report has been submitted, my lord, the learned advocate general.
Yes.
My lord, the report has been submitted on the 29th itself, my lord. It's with the government. Government is yet to take a decision in the matter.
We'll take up.
Commission is also,
So we'll hear the main matter. It's
Please, my lord. There are, in fact, there's one more other connected matter, my lord. I'll give the case number to the court officer.
39 probably.
Court.
Where you filed affidavit.
Please. I'm grateful to.
Learned GA files.
Any date
Private.
convenient, your lordships may be given.
19th, 19th March.
Filing of the
Please.
report by the backward classes commission. Affidavit placed on record, taken on record.
2 days later.
2 days later. 21st March,
Please,
21st.
please.
I may be permitted to return.
Who is appearing for commission, sir?
Belly. She's
Retired.
she's on record, my lord. She's on record.
You are on record for commission.
We'll be filing the wakala.
Memo 28.1 and 2, memo of retirement filed by Shri Vijay Shekhar Reddy D.
Yes,
On
married.
behalf of R4, is permitted to retire.
In both writ-
Don't serve the authority. She undertakes to file wakalat for
Please, madam.
published your wishes.
Number 29. Naveen Chandravi.
For the government, my lord. I appear for the appellants in this matter. My lords had directed us to serve notice to the respondents on the last date. The same has been done and a memo to that effect has also been filed before this honorable court.
Out. You served the other side?
Yes, we have served both
I
respondent number
appear
1
for
and 2.
respondent number 1, my lord, that is the insurance ombudsman.
Insurance. Insurance ombudsman.
So you are for number 1.
Please, in this matter,
Please.
Please.
This will require here. We will not appear. The memo for service of notice to the respondent side is accepted. No, We'll keep let it be like that. So you are
On-
appearing for ombudsman, na?
Please, my lord.
So the AG undertakes to appear for the arbitrator. Students ombuds, delete the from removal of.
The ailment was not disclosed and therefore.
We'll
My lord,
show
may
the-
kindly post this matter for hearing in 2 weeks,
After 4 weeks,
3
it will
weeks.
take time. It appears.
A date may kindly be fixed, my lord.
Date may
It
be
will be given.
somewhere in April, first or second,
Much.
second week of April.
Grateful.
Number 30. Prakash Timana Ibar.
I appear for the complainant in the contempt petition, because that is clubbed with the writ appeal.
There's close to about 300 pages that needs translation. Kindly grant 4 weeks time to comply, ma'am.
11 objections. And bring the incumbent officer in contempt, sir. You are still maintaining Mr. Kumar Naik, who retired 6 months ago.
Pardon,
Party.
A1 is retired, already retired 6 months back.
new commissioner, new commissioner has to be appointed.
That Mr. Kumar Naik, Commissioner of the. Yes. Permit them to implement the incumbent.
Lord, my only submission is that
Right, but contempt is always by name. So the incumbent is already expired.
I will take necessary steps.
Learned advocate, Mr. So-and-so, shall take necessary steps to amend the course title, since respondent 1 incumbent has died.
Grateful.
4 weeks time, ma'am.
So within 2 weeks,
4 weeks, ma'am, because
you comply,
translation,
within that time you comply.
translation for about 300 pages, my lord.
My lord, for
Right.
1 year,
Problem.
since,
In compliance, what is it translate?
Lord, since 1 year, my lord, they have not been able to comply with the office objections.
Appeal. 4 weeks.
Grateful, my lord.
Great.
5th April. Number 31.
I'm for the complainant. I pray for a week's time to verify that office objection,
Weeks time for
to verify that office objection.
25.
You have
Which-
filed some IA number 1, there
For
is
production
office
of document.
objection, you complied, sir.
Please.
Counsel for the complaint, seek time to cure the defect on IA number 1 of 23.
Yeah, still for all.
2 weeks. 25/3. Number 32. Srinivas V.
Affidavit. I have complied with the direction issued by the learned single judge. We have already complied with the order and we filed it. Section 187 of the Karnataka Municipalities Act. As against that matter, a writ petition is filed. This honorable court writ petition entered interim order staying the order passed by this accused.
Client support. Let's check on record and close it. Learned
It
counsel
was the
for-
following, it was the following directions passed by learned single judge, which are sought to be complied with in the present proceedings. Then paragraph 2 of the order, page 9. Full stop. When the contempt application comes up for consideration, learned advocate Mr.
G. M. Ananda.
A. Manan
Yes.
tenders affidavit stating that the order under section 187 of the Karnataka Municipalities Act 1964 is passed. And that accordingly the directions are complied with. The affidavit is taken on record since the order is complete. Who is for the other side?
Srinivas V.
Srinivas.
V. Srinivas.
Close it.
Full stop. Since the order is complied with, the proceedings are closed.
33. Lata Shetty.
Appearing for the statement.
That's in 33.4. Last date of hearing, your lordship directed me to memo to show the counsels who are appearing for the respondents in the writ petition, your lordship to serve upon them. Meeting that memo, ma'am.
Lords, the respondents were represented in the writ petition, the council.
You have to serve the copy on the advocate.
Please, Lords, I may be permitted.
Served.
No, Lords, I may be permitted to serve, Lords. On the last date of hearing, the Lordships are directed to file a memo to that extent, to seek permission to serve on the councils for the.
Why, memo, why is required a prayer is seeking permission to serve on the.
So where is the question of permission?
Last date.
Last time I had asked for such permission, Lords, the Lordships are directed to file a memo.
Memo regarding?
Memo regarding seeking permission to serve on the councils representing the respondents in the writ petition.
My lord, the last occasion, the appellants had to file a memo indicating the rank of the parties and have it served. That is the order dated 5/2/24.
5/2. Must not have been passed.
No such orders.
There is no such order.
There was an oral.
Whatever you want to do, you do.
Senate counsel for the appellant seek permission to serve the counsel for the respondents appearing before the writ court. Permitted.
It's interim order has to be extended in the matter.
Interim order.
Much obliged.
33.5, my lord, all respondent, all copies served to all respondents, my
My
lord.
lord, I appear for the
By the
original
30 per
petitioners in the writ petition. My lord, let a time frame be fixed for compliance of the office objection.
Lords, only regarding the service of this
Because-
one. There are no office objections
My lord,
regarding the other.
With regard to 33.1,
3.1.
writ appeal 1102 of 22. was
Whatever the
referred
office
first.
objections are
And there's
there,
an
please
interim
comply,
order
sir.
with respect to that matter, my lord. The rest of the matters were filed and have been clubbed because of the similar issue being involved in all the writ appeals. My lord, there is no office objection with regard to 33.1, the first writ appeal. Later, my lord, for the only reason, my lord, others are been enjoying the benefit of the interim order. That's the reason I am praying for a
Will take up
time frame.
date.
Please, my lords, will take.
Please.
Much obliged. Interim order first. Much obliged.
5th of April,
Much obliged.
34. Aditya D.
University has filed.
In the guise of filing the affidavit, the directions of this division bench were not been adhered to. My lord, the page 10 of the counter filed by the respondent. Page 10.
He is not eligible for the post, promotion considered is not eligible.
Page 10, they say that the candidate is not fit to be considered to be appointed for the post of associate professor in the subject veterinary microbiology. But kindly to page 50 of my contempt petition, my lord, inner page 12, the division bench has very categorically observed my eligibility.
Where is that order of division bench?
My lord, the division bench order is page 50 of my petition.
15 of the petition.
50, inner page 12, my lord. Inner page 12. The petitioner has been working as deputation.
50.
50. 50.
50.
50. Sorry, ma'am.
Yeah, we consider the same.
My lord, the respondent.
This order is in case of the same petitioner.
Same petition, division bench. The petitioner has been working on deputation to the university as assistant professor in his pay scale with effect from 4/10/2008. It is true that he holds a PhD degree in veterinary microbiology and that he has been presently teaching as an assistant professor in the veterinary college of this university. His candidature was considered duly along with the other qualified candidates. My qualification was not under dispute.
Let the committee take a call, sir.
No, committee, the committee report, my
To
lord.
constitute the committee has to consider promotion.
No, committee has to consider But the committee's observation, which has been imbibed with along with the affidavit,
My lord,
page
the
10.
Committee has already considered the claim, my lord. It has
No,
considered.
no,
and
no,
it has-
not consideration. They said, I am not fit. I am not fit for selection. Whereas the division bench has observed.
The direction is only to consider, even at page 50.
50. To
Even at-
consider, but
Consider.
the language employed, my lord, the candidate is not fit to be considered.
Let us,
Page 50 of the affidavit. Page 10.
it means that not fit to be appointed.
No, that is correct, but at the same time, in the writ appeal, they state, I have got all eligibility and all those things. Even the associate professor.
It may be a wrong decision on merit on part of the committee, but then you challenge it substantively.
No, no.
Because,
the
because at page 50 as well as in the direction under contempt, both the words are considered.
No, no, consider means not
Consider means
willful
consider.
rejection, my lord. When I am had a very qualification to be an associate
Consider
professor.
doesn't indicate the ready entitlement.
No, consider means not consider negatively, because the negative consideration only has brought me to the writ petition and writ appeal.
Not express on your opinion. That is.
Division bench
Court
has
has, on the
last
contrary,
sentence.
clarifies that the court is not expressing any opinion on the merits.
No, no, court has not expressed anything about.
That is, in that light, consider.
But court direction, my lord, it's whims and fancies.
We are in contempt jurisdiction.
Yeah, I concur, my lord. In the contempt jurisdiction also, when the court has formed a opinion to consider, while considering it is only making somersault of its own earlier decision, which it has been brought to the court notice in writ appeal, that I got a very eligibility. And now I am telling I am not fit.
So you challenge it substantively by filing a substantive writ petition.
With that liberty, it may be disposed.
Permission is not required to be given. It is open.
Because already I got 3 rounds of litigation, my lord.
So heard learned, your senior advocate?
Yes, yes.
Learned senior advocate, so and so, assisted by learned advocate, so and so, for the complainant and learned government leader, who, Mr. S. Mahendra, as well as learned.
You are
advocate.
appearing for the university.
University, accused number
So
1.
and so for the respondent number 2 university,
Yeah, 1.
1 university. For the respective respondents. Say that. Full stop. It was the following order. Dated 15 February 23, passed by learned single judge. While disposing of the writ petition, that is brought under contempt jurisdiction of this court. Quote the order, page 20. Under the aforesaid, as per the aforesaid directions, the petitioner's candidature for the appointment to the post of associate professor was required to be considered by the selection committee as directed by the division bench on the writ appeal number 3035 of 19 and 3036 of 19. Keeping in mind the University Grant Commission regulations on age limit. Full stop. In response to the present contempt application, counter affidavit came to be filed by on behalf of the accused. That's the Register of the Karnataka Veterinary Animal and Fisheries Sciences University, Bidar. In that affidavit, inter alia, decision of the selection committee dated 3/5/23 was produced. The minutes of the committee finally recorded that with an inward comma, the candidate is not fit to be considered to be appointed for the post of associate professor in the subject of veterinary microbiology. Paragraph. It was vehemently submitted by learned senior advocate that the decision of the committee still amounts to committing contempt of the directions of the court, inasmuch as the directions of learned single judge in terms provided that the case of the petitioner was required to be considered in light of the order of the division bench in the writ appeal, which was in the case of the very petitioner. Paragraph. The order of the division bench in the writ appeal proceedings figures on record. Where is that?
Last sentence.
50, page 50.
56.
56. Figures on record. Paragraph. It is relevant to reproduce the directions of the division bench in the writ appeal number so and so, so and so. The operative portion reads as under, and quote paragraph 11 on page 56. Full stop. Reading the aforesaid directions paragraph makes it abundantly clear that even the division bench directed only to consider the case of the appellant for appointment to the post of the associate professor in accordance with the 2001 rules. It was further observed that if the appellant is found entitled to the post, he shall be given the consequential benefits. The court further expressed that it did not express any opinion with regard to the claim of the appellant. Full stop. Direction to consider in inward comma a case does not mean that the petitioner is readily entitled to be appointed as post. Full stop. The consideration is always on merits to be undertaken by the authority which is directed to consider the case of the appellant. Full stop. The selection committee has taken a decision stating that the candidate is not fit to be considered to be appointed to the post. Paragraph. It is not possible to countenance the submission of learned senior advocate that the decision passed by the selection committee amounts to contempt of the court. The case of the petitioner has been considered and he is found fit. He is found not fit to be appointed. Full stop. If the complainant is aggrieved by the said decision, it is always open for the complainant to substantively challenge the said decision. Full stop. However, the contempt no more survives and it is disposed of.
Number 35, K.S. Narayan Swamy.
In this case, my lord, I pray for a 2 weeks time to complete the observation, my lord. Translated copies are required to be filed.
Which, how much time?
Please, my lord.
How much time?
2 weeks, my lord.
2 weeks.
Applies.
2 weeks time is granted to remove the officer.
5th April. Number 36, Mr. Subramania Bhattiyam.
I appear on behalf of the complainant, my lord. My lord, they have filed a counter affidavit, my lord, as per which the order passed by the Honorable learned single judge regarding payment of salaries complied with, my lord.
Page?
Operative portion of the order is page 86, my lord.
Page 80.
86.
86. No, which is the order to be complied with?
Page number 86.
86.
Order
Big
to-
different.
Order of the learned single judge at.
One second, yes,
It
86.
starts from
Yes,
73.
yes.
My lord, the order A.
Accused number 2 has filed the complaints affidavit. Commissioner.
Counter defeated by second respondent.
I appear on behalf of the accused number 2, my lords. I filed my counter saying.
You have filed the counter.
Please. We have paid 2,50,000.
So this order dated 28/8/23 is passed by whom? Deputy Commissioner. Madam,
Commissioner Municipal.
page 4 of your counter. That is the single judge's order. Then 28/8/23 is produced.
28
Which order?
28/8/2023 is passed by the.
The same.
Is passed by the commissioner, ma'am.
Commissioner, my lord, as per the
Where-
direction.
Where is that order? Page?
Page number 94, my lord, it starts from 94.
76, there are. order
Translation
for
is at
payment.
101.
So payment is made. Only
Payment is made.
Only regularization is refused.
Regularization can't be considered because it's not a.
Even endorsement as per annexure A7, A5, my lord, in their counter stating that I cannot be treated as a regular employee. That order have challenged, my lord, and so far as the payment of salary is concerned, as per annexure R3, my lord, they stated that they have paid.
So then compliance is done.
Very well.
Yes.
As
Even
per,
there was no prayer in the main petition about regularization.
Yes, my lord, there was only a prayer
But in
was to
any case-
consider my, if any representation is submitted by
Same
the.
as previous matter. You
Yes,
challenge
sir.
it.
as per class C, deputy commissioner passed an order as per R5. And my lord, accused number 2 paid the whatever arrears, salary. To the extent of 2,34,871 as per annexure R3 paid number 73.
78,
73.
76.
76.
Yes.
2,31,000.
So 2,34,087.
Yes.
Yes, your lordship.
So what?
Yes, on that, and on that ground, my lord, this may be dropped, my lord, complaint proceedings.
Will pass the order. So salary is paid, salary amount is paid.
Yes, my lord,
The other part is complied with by taking a decision.
please, your
If you want to challenge it, liberty is reserved.
yes, please, my lord.
Yes.
Take the name of the advocate and give.
Paid.
Disposed of goods.
Give the complaint. But I've undertaken in a connected writ petition not to precipitate this particular contempt minutes. Matter can be had in the second week of April minutes. That matters like it be listed in the first week of April.
You have filed the compliance, ma'am.
We had filed a compliance affidavit. My lord. The issue here is with regard to certain payments that had to be made to the petitioner. Now, they filed a writ petition to consider representation to release about 16 odd crores. Initially, my lords, the corporation had taken a stand that no amounts would be paid, and amounts would be paid only as per the seniority. Then subsequently, my lords, 50% was released, which the complainant was kind enough to acknowledge. And then in the meantime, my lords, a writ petition came to be filed. Now, why that payment was withheld initially was because a special investigating team was constituted to look into various contracts awarded by the corporation. And that special investigating team was looking into the work done and various other allegations that were there. Then subsequently, Manoj, that special investigating team was disbanded, and a retired honorable judge of this honorable court was appointed as a one-man commission to look into the very same allegations. Now, that is pending before the learned single judge. And in fact, my lords, the state had undertaken before the learned single judge that we would request the one-man commission, the retired honorable judge, to look into the allegations vis-a-vis the petitioner as soon as possible and file a. So in the meantime, another 25% also has been paid. So 75% till date has been paid, but
not received.
So
We put off for some time.
Yes, no, very well, because that matter is coming up on 2nd of April.
Coming
So
up on
maybe
2nd
the
of
week
April,
after
so my request is the week after, 2nd week of April, this matter is posted.
Third week of April.
Very well.
Very well.
Obliged.
I appear for the complainant in this.
Where is the order under contempt? Page?
My lord, page number 82, my lord.
Page 82.
It is an injunction order restraining the defendants.
Interim.
IA number 1 and 2. 82, my lord. Third paragraph. Further, the defendants, their men, servants, agents are hereby restrained from executing, registering any writing, deed or document.
Your remedy under 39(2)(a).
My lord, the suit is disposed.
Even then 39(2)(a) will lie.
My lord, the court will become a functus officium.
39(2) are independent proceedings. Even if the suit is disposed, they will lie.
And under section 10, my lord, your lordships have the jurisdiction.
Exercise.
Not only under article 215, but also in respect of any other court. Notice has been directed, my lord, already.
It's already disposed of, you invoke order 21, sir.
Suit is disposed, my lord. Suit is disposed. During the pendency of the suit, this document has been executed by the accused.
What is the fate of the suit?
Suit partially decreed in my favor.
Reference to this relief.
Yes, with reference to these properties, the suit is dismissed. But the appeal is pending. My lord, the appeal is pending. In the appeal also, there is a like order.
Then interim order in the suit cannot be enforced.
My lord, I did not get your lordship.
You are saying that
Since
this
main
part
suit
of
with
the.
respect to this is already dismissed, where is the question of enforcing in
My
interim?
lord, the order was there. The order has been violated. The order has been violated. Order has been violated. Ought not to have been done.
How it will survive when this relief is denied in the main suit?
My lord, this relief.
Academic at
No,
the
no,
best.
1 minute.
At the best.
There is an appeal filed, and in the appeal, there is a like order. But let us assume, my lord, that the suit is totally dismissed. The point is that there is a violation of the injunction, and they are liable to answer to your lordships.
Even then, why should we exercise the contempt?
My lord, there is a violation of, there was a court order. It will prejudice me. If I succeed in the appeal, my lord, it will cause enormous prejudice to me.
Where is the decree?
Page 85 onwards, my lord. So much so, the first accused 1 to 5, you even have not cared to file. They replied before your lordship.
What seems they are accused or not?
Who appeal?
Mr. Srinivas Reddy,
Not there.
2 times, my lord, they have sought time, extension of time twice.
accused persons, they are residing. out.
We'll wait for a week for them. Then we'll issue some coercive order.
The R.V. Srinivas Reddy,
Is LRs, my lord. The LRs of the first defendant are the accused.
Against the LRs, you are enforcing the order against the LRs.
LRs and the purchasers under the agreement. Knowing they are the abettors, knowing fully well that there is an injunction, they have agreed to buy the suit schedule property. But the matter was heard at the first hearing at length.
We'll put up for a week, then we'll consider.
Of the appearance of.
Not that urgent also. Let the other side be.
Milord, for the other accused, 6, 7 and 8, notice may be awaited, my lord. They are in Hyderabad.
So let us await it.
Await notice of A6 to A8. None appears for the A1 to A5. Date April.
5th April. Number 39,
April 5th, sir, next.
5th April.
For complainant.
Lord,
39,
in this
Tenancy
matter, we have
agreement.
preferred an appeal. Lord. Maybe
In the last
called along.
occasion, my lord, this honorable court has issued bailable warrant to the accused. But the office says that it is not executed, and also there is a direction to present the Tahsildar before this honorable court
Tahsildar
today.
Tumkur.
Tahsildar Tumkur is present before the court. Lord. He is present before the court. And Lord, we have preferred an appeal in writ appeal number 250 of 2024. This contempt petition may be called along with the writ appeal.
Head number 1 is present. Learned GA submits that the state has preferred the appeal in WA 250.
Mere filing of appeal does not.
Tag this contempt to writ appeal.
They have right to prefer appeal, contempt has to wait,
Please, please.
unless it is in so aggravated form that it can't wait up outcome of appeal.
Please.
Public.
5th of April. So number 40, to Mahesh, yes. I care for the complainant.
Non-compliance,
Lordship, I'm for
A1.
accused number 2, your lordship.
Annum
Will come-
Bharadwaj.
We will comply the order of the learned in their judge, your lordship. We need some more time, your lordship. We will do it.
They have already complied and they have given me an endorsement. I do not know what.
That was the
Challenge
instruction
itself.
given, your lordship.
They have given me
You are for the complainant,
I am for the complainant.
then why you argue?
I don't know why.
Your lordship, that was the instruction I.
So it's fair enough. Learned advocate, Mr. So and so fairly stated that the order and contempt is complied with. Full stop. Learned advocate, miss, what is your good name?
Medini Rao. Medini Rao.
Confirms the compliance. Full stop. The proceedings of contempt are closed. That's all? Mr. Counsel, that is anything more? No.
Number 41, with Anisha L.
How come that you did not know the compliance?
The instruction given by my clients, your lordship, that they want more time. That's-
Number 41,
Even yesterday night itself. The accused called me up and he had sent it himself.
Okay.
So you're fair enough, yes.
We have filed memo for retirement. We have filed memo for retirement.
Of retirement. Where is your party, Ratnama?
with Ratnamba and other.
ನಿಮ್ ಲಾಯರ್ ನಿಮ್ಮಿಂದ ರಿಟೈರ್ಡ್ ಆಗಿದ್ದಾರೆ ಏನ್ ಮಾಡ್ತೀರಿ ರತ್ನಮ್ನವ್ರ? Direct Kotira, okay. Learned counsel for the appellant, memo for retirement on behalf, filed on behalf of the appellant is accepted. Counsel is permitted to retire, appellants are present. Seeking time to engage a new counsel.
Lord, may I make one submission? Lord, I take notice for respondents 9 to 11. Connected matters are pending in writ appeal 210 of 23.
Here
So
text
this
notice to
appeal may
R
be
9 to
connected
11.
along with that.
Post along with 210. ಆಯ್ತು ವಕೀಲರು ಇಟ್ಕೊಳ್ಳಿ ಹಾ
Much of.
Number 42,
In this matter, I pray for 2 weeks' time to file counter. There is no contempt in fact.
2 weeks' time they are seeking may be granted.
Learned GS 6 2 weeks time. Counsel for the complainant has no objection.
2 weeks. Obliged.
14. Number 43 to Kumar KG.
Bill number 43, my lord, I appear for the accused 1, 2, and 3.
Do
I
it,
request-
when will do?
My lord,
12 weeks,
2 weeks' time, my lord, may I?
further 2 weeks.
I'll comply.
Please,
My lord.
We'll record the statement.
please, ma'am.
May I
Lord learned counsels with respect to parties. As per order dated 25th July 23, passed by learned single judge in writ petition number 8476 of 2023. Respondent, it was directed by learned single judge that respond 2 to 4. Shall consider the representations dated 17/23 and 17/1/23. Both 71/23.
There are two representatives.
Two representations dated 17/23 made by the petitioners. The representations are to be considered within outer limit of 12 weeks. Full stop. While it is true that paragraph 12 week period of 12 weeks has expired, learned advocate for the accused when the proceeding came up before the court today, stated that within further 2 weeks' time.
Yes, ma'am.
The direction shall be complied with and the appropriate decision on the representation shall be taken. Also, this statement satisfies the learned advocate of the complainant.
Please.
Full stop. My lord, may I request, my lord, Mr. B.L. Sanjeev's name may be short.
Time limit for compliance shall be abided by.
Yaar in place of
Mr.
The
Chilla.
matter has been assigned to BL Sanjeev.
BL Sanjeev.
Yes, ma'am.
Office to show the name of Mr. BL Sanjeev in place of P. Chidan.
Chilla. Much obliged.
7 to 8.
This
44,
But in this case, I have complied the direction, my lord, because I have served the copy to all the respondent, vacating stay application, my lord.
I pay for respondents 1, 4, and 5, madam.
Is an order of status quo.
Status quo is granted after hearing both the parties. Question of vacating, my lord, never arise.
But here is a case, otherwise matter may be heard, my lord, because inordinate delay of 12 years in challenging the writ petition. Acquisition proceedings are completed in the year 2010. That is the
My
observation.
lord may.
And the petitioner is a subsequent purchaser. How can they maintain the writ petition? That is the observation of the learned single judge. And the development work is stalled, my lord. That is the reason.
challenging acquisition after 12 years.
Yes, my lord, 12 years. In view of Banda Development Authority case read by the learned single judge, my lord. And taken position, I have produced all this 28/7, 28/8. And the petitioner is a subsequent, came in the picture 2016.
You are for industrial area development?
Yes, yes, ma'am, yes, ma'am.
But I'm sorry to say, my lord, petition is not a subsequent purchaser at all. But he purchased the property on 8/2/99.
Who?
If the
Appellant,
appellant's husband.
8 to 19.
May I make an appeal to your lordship, matter may be posted for admission so that, my lord, it can be resolved. Today is not, I have
Today,
no objection if you not chase up the matter.
you are not ready,
I'm ready.
so you want time.
No, I'm ready.
We'll
Because,
proceed for a preliminary hearing.
Yes, that, otherwise not, I would not.
Preliminary hearing told on, we'll take up the both.
Yes, ma'am. One date may be given so that.
That time and all can hear
Both
the.
sides for stand over to preliminary hearing.
In the April. First
No,
week of-
my lord, I am sorry. My request is, my lord, because already 14 years, my lord. we-
Not, there is an interim order before the non-single judge.
That's why you operate. So you have taken possession or not?
No, my lord.
So we're taking
If you
position.
have taken position, why
produced
they would not apply for a vacating?
What is the
interim order?
document? Everything is over, my lord.
But status quo will never come in the way if they take a
According
position.
to you, when the proceedings were over?
Pardon, madam?
According to you, when the proceedings became?
2010, my lord, 2010, we have produced the document.
2010.
Yes, my lord.
My lord, may I make an appeal to your lordship?
It is
Lord?
on 13/5/2010.
The reply is filed without disclosing on what date award is
And they
passed.
have handed over to the board on 17/5/2010, my lord. And I have produced the documents also.
Well, here.
But award copy is not forthcoming.
Within the third week of, fourth week of.
Last week of March.
Please, madam.
But all records are necessary, my lord.
28 March.
All records are necessary. Why? Because, my lord, they filed reply statement.
That we'll see when we hear them.
Yes. Interim order may be fitting.
28 March. Number 45.
Please, ma'am. That I am appearing for the complaint in this matter, Malad.
This is interim order.
That interim order, Malad.
So
That what happened,
interim
Malad?
order passed by this court or?
This court, Malad.
Court below.
This court, Malad.
So then why
That your
should we-
lordship may kindly
why-
page 11, Malad. Page 11. actually.
So what is happening to the main matter?
Main matter is pending, Malad.
Pending.
Pending.
Order of status.
Admittedly, the write down. Order brought under contempt is an interim order passed by law on a single judge in the pending writ petition. Full stop. By very nature of the order, paragraph. The rights of the either of the parties are not finally crystallized. Full stop. Since the proceedings are at large on merits before law on a single judge, this court does not see any reason to exercise the contempt jurisdiction. The contempt application is dismissed.
No, Malad. Yeah, this contempt is connected with writ petition, pending writ petition, Malad.
Interim order we don't.
Because, Malad, they have
Unless-
received the.
Unless,
that
unless the order is trapping of finality, you are.
Remember that, what happened, Malad, during the pendency of the writ petition, Malad, third respondent has received the amount from the public, Malad. We have challenging the
We open
legality
for
and
the-
correctness of the managing committee list, Malad. That was not approved by the
Go-
competent authority, Malad.
Make or raise your grievance before learn a single judge. It will be open for the complainant to raise grievance. Before learn a single judge in the pending proceedings. Yes, next.
Number 46, Mr. S.V. Bhatt.
For the complaining. The final order of this honorable court at annexure B page
Who
16.
appeared for the respondent?
Notice is yet to be.
Notice.
Office objection. Name of A1 to be stated. in
A1,
past
I may be
sir.
permitted to delete A1, my lord. A1, I am not seeking any relief against A1.
Honored
A2.
counsel 6 permission delete
Yes, my lord. D,
A1,
A1.
A1, accused number 1. He is permitted at his cost and consequences. To the rest of the
Notice
respondent
to
accused, there shall be notice returnable on second week of, first week of April.
Please.
Yes. By the time it will comply with.
5th of April.
Hopefully. I don't think it is payment of compensation, my lord.
Number 47, Mr. S.B. Mukanappa.
Apprentice, I paid the court fees, my lord. I paid the court fees.
There is a delay of 89 days.
53(2).
KSRTC.
The learned single judgment before the learned single judgment.
Renuka. Council Srimati HR Renuka is directed to take notice for the respondent.
Okay,
Lord, I am the amicus, this matter, manual scavenging matter, my lord. We had filed a writ petition in response to which, my lord, on 25/1, the state has filed its response. Now, the major issue remains to be, my lord, that compensation is not paid in accordance with the directions issued by the apex court in Balram Singh's case.
Ivan Kumar BS.
The
Sir, you are not please set up the
matters were-
48.1, 2, 3, 4,
The
5.
matter were pending before the learned single judge.
So now please file the
Now
second.
I'll file it.
no, they are, my lord, incidental matters. I only made a mention because the compensation is not paid, but lordships may see, my lord, page 24 of my writ petition. There is a clear direction, my lord, to the state and the union to make payments regarding the, my lord, I'll complete my submission, please. The central government and state government are, my lord, required to pay these amounts in case of death and in case of other, my lord, mishaps. So the respectful submission is, my lord, that this direction is not complied with. And what, my lord, the state has filed, your lordships will find in the compliance affidavit at page 4, my lord, for instance. Page 5, my lord, I'm sorry.
R10 and 13 Wakalat learned advocates, we have filed the Wakalat for R10 by the office of judge.
The compensations are paltry sums, my lord. A few thousands are paid. And the compliance of the Balram Singh's judgment, my lord, is one aspect. Even otherwise, my lord, the compensation amount by any standards is far less than, lord, reasonable compensation. Lordships may see, for instance, page 3, my lord, paragraph Roman 1, the Ramnagara incident, my lord, is narrated there. I'm reading from page 3, my lord, from the middle of that paragraph, the compliance affidavit.
Because it's.
Lordships have it.
Let the things be put in order in terms of, then we'll hear.
And even last time, Madam Jaina Kotari made a submission regarding
Time to file
complaints.
rejoinder.
Yes, my lords.
That is one, the
Filing my
issue is, my
rejoinder.
lord, there is one matter that is tagged along with these matters.
Where is that judgment you're hearing?
Balram Singh's judgment, I have extracted, my lord, not produced.
But a copy was given on the last date.
On the
my lord.
last date, my lord, it is on record.
It's on record, my lord.
2023, my lord, SEC online 1386. It is, my lord, part of the record.
2023 SCC online.
Yes, my lord.
May I pass on it, my lord?
Copy has,
And
Copy is already there.
copy is on record, my lord.
Now, there is, my lord, one other case that is tagged in which, my lord, the amounts may be disbursed because these victims are not getting, my lord, the LRs of the victims are not getting the amount. There is this case, my lord, that is tagged.
48.13, my lord. In 48.13,
13.
my lord, in that I appear for the impleading applicants. In that, there is an amount of 20 lakhs that has been deposited by the petitioners. That amount, my lord, is in respect of the two people who passed away while doing manual scavenging. That may be dispersed, my lord, to the LRs in 48.13.
Petitioner himself has filed an application for the disbursement of amount. Today, I am producing bank details of the victim's family, my lord. They have sent a request letter to us along with the bank details.
You don't have any objection for this?
You can go to.
It can be dispersed, my lord.
go to.
Victims, my lord, victim's family.
Please, this.
It's with the registry. This
The
is, my
amount
lord,
has been deposited in before this court, my lord.
that amount I am praying, lord, may be dispersed to the concerned victims.
That will pass.
Please, 815.
One,
Oh, 13, 48.13.
It is in 48.13. ನಾನು ಹೇಳಿದ್ದು ನೀವು ಹೇಳಿದ್ದು. ನೀವು ಮತ್ತೆ ಸ್ವಲ್ಪ
exports. They are requesting that it may be dispersed to the LR of the purchase. 815 record is there. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಎಲ್ಲ ಅವನೇ
to the mother, to the wife, my lord, of the person who has passed away. In both the cases,
They have appointed one person. They have
Please.
given a request letter. In the letter, they have appointed one person as their representative. That
Yes,
one
my lord.
person representative bank
the
details.
details of that.
Give
the details are there, my lord.
Memo I have
So,
filed.
in the memo.
Page number 1 is a letter from Gostam.
This one, 29th of February.
Please.
815.
Srimati Govindama.
Please,
spouse
the wife of the deceased man.
One of the deceased.
Wife of the deceased.
So this is interim complaint.
Please, my lord. 10 lakhs had been, they had been directed to deposit an amount of 20 lakhs totally.
You are for?
I'm for the impleading applicants in this matter, my lord. That is the people who have passed the,
LRs of the
please, my lord, the LRs of the deceased, please.
I appeal for petition in this matter.
In fact, my lords, if I may make one submission, as per the recent
So it is to be passed in
judgment,
this
the
writ
pronouncing case,
48.1.
48 point.
48.1.
The incidental cases may be, my lord, you
ನಮ್ದೆಲ್ಲ ವಾಪಸ್ learn
we
single
want
judge.
that to be sent
if it-
back.
Similar matters are pending before the learned single judge. So are somehow tagged here, my lords. If the matter is sent back to the learned single judge, 48.2, 48.3, my lords.
Some of the matters
Whose
are not
order it was
connected,
tagged?
my lord.
The
Not-
incidents are- Yes, my lord, that
Because
So it has to be dealing from the PILs.
It
single
could be
use.
dealing from the PIL, my lords. It is a policy decision which will have to be dealt by the learned single judge. It is with regard to rehabilitation of the manual scavengers.
No, I made a submission on the last date, my lord, taking these cases because there is generic direction if my lords were to pass in these cases, which may have some bearing on the pending case.
Let it be together, all for the time being.
Please.
yes.
It must be by some judicial order, Mr.
Yes.
Last dated.
Could I make one submission on this, my lords? Apologies. Could I make one submission? My lords, on the last occasion, a submission was also made to tag these matters because, my lords, as per the Balram Singh judgment, the compensation now is 30 lakhs for every person who has died and not just 10 lakhs. And in many of these cases, my lords, just interim directions of 10 lakhs were made. So therefore, my lords, some orders, my lords, need to pass on this, my lords.
Page
Grateful.
24, my lord, I have extracted the order. That was my first submission. In fact, my lord, the compensation amount paid by the state is in some few thousands. There is no compliance, not even substantial compliance or even semblance of compliance in these matters. The 30 lakhs, my lord, is the amount directed to be ordered, directed to be paid for death victims.
We'll keep tomorrow at 11, at 10:30.
Please,
Second set, they are.
no,
I'll
those
second
issues.
Plus, in my case, initially was fixed at rupees 10 lakhs. Subsequently, they reduced to 1 lakh. This honorable court, learned single judge directed them to pay 1 lakh at least. Still, that amount is also not been paid. That is the reason why I filed a writ petition challenging those orders, reducing from 10 lakhs to 1 lakh.
Today, Mr. Counsel, not e-tagging any matter.
Please.
On the next day, we'll see.
My lords,
Just let me
can this
have the-
matter, can this matter be taken on Monday? My lords, the Balram Singh matter is listed in the Supreme Court tomorrow.
My lord, for the moment, my lord, could, insofar as 40,
Even the amount may be on next.
There is
my lord,
already a
insofar
direction.
as that, my
Sorry.
lord, that amount of 10 lakhs has already been deposited by them before this honorable court. Neither do the petitioners have.
Wait for a week. I may go through.
Please, my lord.
That is the only reason.
Since, the only request was since they
Take
have
up
already passed away in
comprehensively.
December, my lord, and still the amount had not been
That's
paid. My lord may also note in the first matter, I have actually filed a reply. I'm the petitioner in the first matter. In that, I have filed a reply detailing out each of these aspects, looking at the compliance report that has been filed by the state, and also looking at Balram Singh, looking at who is the appropriate authority and agency to implement each of the directions in Balram Singh. My lord may also have a look at the reply that has been filed by me, which details out the various aspects.
Honorable court may direct the union also to file a response.
I have filed my response, my lord. On 30th Jan 2024.
What are the copy on the?
I have served it to him through email, my lord.
I'll read.
So we shall list it on
That is the office objection. That is the office objection.
18th.
Please.
Meanwhile, I'll file my second set also.
File the second.
Monday, my lord.
Not 18th. 18th is Monday.
The one,
Grateful.
please.
Grateful, my lord.
48.1 amendment of cost rate lack 48.1 Sheila Nish. High-Court legal HCLC ಇಂದ ಹಾಕಿರೋದು ನೋಡಿ ಮೇಡಮ್ some amendment you required, please carry.
1 week's time.
18th.
Court officer? Court officer? Court officer?
The writ appeal so and so it is the order passed on back and ಎಲ್ಲ
Court officer?
ಯಾರ್ದು ಡಿಸೈಡ್ ಮಾಡಿದ್ರಿ?
Court officer? Court officer?
Then, you know, how will you do with them? Right?
Court officer? Court officer? Hello?
ಹೇಳಿ ಸರ್ ಕೇಳಿಸ್ತಿದೆ. ಸರ್ ಒಂದು ನಿಮಿಷ ಫೋನ್
Court officer? Court officer?
ಸರ್ ಸರ್ ಹೇಳಿ ಸರ್.
I appear for the respondent petition. And in this matter. Filed an application for vacating stay.
This is a case where
Man. That may kindly see in this matter. The writ petitions are filed challenging the proceedings of the District Task Force Committee as well as the suspension order issued by the Forest Department. The reason being, Lord, all these quarry leases are situated within 1 kilometer of notified Kappadgudda Wildlife Sanctuary. It is an admitted fact that, Lord, all the quarry leases are within 1 kilometer from the notified Kappadgudda Wildlife Sanctuary. The eco-sensitive zone notification has not been issued in this case. Therefore, Lord, the Honorable Apex Court in Godavaman's case clearly stated that there shall be no non-forestry activity within 1 kilometer of the wildlife sanctuary or national park. This has to be maintained as protected area. The recent orders of the Honorable Apex Court in Godavaman case, that is on 26/4/2023, as well as on 28/4/2023, which I have placed on record, my lord. Compilation of change.
even we have produced them.
On 31st January 2024.
if I may be permitted, my lord.
Your Lordship have 31st January. May I take your Lordship to page number 48, para 56.4. These are the directions, Lord, in para 56. Lord. There is a clear direction.
22 order. 3622.
Lord, before that, I may be permitted to read 54 also. 54 in page number 44.
3622.
In the first engagement.
3622.
In our opinion,
now Petitioner.
clarified.
Yes.
page number 44.
Yes.
Lord. Annexure D is Lord. Page number 77, Lord. 77, and translation is at 91.
But the order passed is on a different provision of law, not what my learned friend is saying.
Page number 114, para 2 is relevant in that resolution. Further, a detailed discussion. Mary. Further, a detailed discussion has been conducted in the meeting as concerned to the order of the Honorable High Court in writ petition. It is Honorable Supreme Court, my lord. There's a mistake. Petitioner number 202 of 1994 dated 4/8/2006 and the order in interlocutory application 1000 of 2003 dated 3/6/2022, which I was referring to, my lord, in my compilation. It is unanimously decided in the meeting to suspend 14 stone quarry leases within 1 kilometer boundary of the Kappadguda Wildlife Sanctuary and to cancel the lease if any violation is found. Further, it is decided to write a letter to the Director of Department of Mines and Geology and Forest Department about action taken. District Task Force Committee meeting has instructed the senior geologist to follow the order of the Honorable Supreme Court and unanimously approved in the meeting. Now, may I take your lordship to the order of the Honorable Apex Court? Yes, 54. Before that, may be permitted to read. 54. Para 54, page number 44.
Yes.
In that complaint. In our opinion, the guidelines framed on 9/2/2011 appears to be reasonable, and we accept the view of the standing committee that the uniform guidelines may not be possible in respect of the sanctuary or national park or maintaining ESZ. We are of the opinion, however, that a minimum 1 kilometer eco-sensitive zone ought to be maintained in respect of the protected forests, which forms part of the recommendation of CEC in relation to category B protected forest. This would be the standard formula subject to the changes in special circumstances. We have considered CEC's recommendation that ESZ should be relatable to the area covered by the protected forest. But standing committee's view that the area protected forest may not always be reasonable criteria also merits consideration. It was argued before us that 1 kilometer wide no development zone may not be feasible in all cases, and specific instances were given in Sanjay Gandhi National Park and Green Day National Park in Mumbai and Chennai metropolises respectively, which have been have urban activities in very close proximity. Then may I take your lordships to 56.4. Mining within national parks and wildlife sanctuaries. This is in 56, Lord, directions were issued in para 56. 56.4 pertain to mining within the national parks, wildlife sanctuaries shall not be permitted. Then, Lord, 56.8 is relevant. In respect of sanctuaries or national parks for which proposal of state or union territory has not been given, the 10-kilometer buffer zone of ESJ, eco-sensitive zone, as indicated in the order passed by the court on 4/12/2016 in Goa Foundation and also contained in the guidelines 9/2011 shall be implemented. In this case also, Lord, eco-sensitive zone notification has not been published. Within that area, the entire set of restrictions concerning to eco-sensitive zone shall operate till final decision in this regard is arrived at. Lord, thereafter, Lord, this order has been modified in the subsequent order. May I take your lordships to the next judgment, next order which I produced. It starts from page number 50. Page number 100, 100 is the relevant, para 65. Page 100, para 65. We also modify the directions contained in paragraph 56.4 of the order dated 3rd June 2022, Supra, and direct that mining within the national park and wildlife sanctuary and within an area of 1 kilometer from the boundary of such national park, wildlife sanctuary shall not be permissible. There is total prohibition, Lord. Within 1 kilometer area from the boundary of national park. Further, Lord, one more order has been passed by the apex court as per the order produced at page number 102. The relevant para is at page number 111, 111, para 23. Lord, this is in respect of where, Lord, eco-sensitive zone notification has been published, in which the eco-sensitive zone delineation is happened. In those cases, we clarify that even if in a particular case, the eco-sensitive zone is more than 1 kilometer, till if the concerned area where mining is proposed to falls within eco-sensitive zone, the mining activities will not be permitted, even if it falls in an area which is beyond 1 kilometer from the boundary of the protected area. The prohibition of 1 kilometer from the boundary of protected area is only with regard to the cases where the boundary of eco-sensitive zone is less than 1 kilometer. Even in the eco-sensitive zone notification, even if it is less than 1 kilometer from the boundary of the sanctuary, only in such cases, ban on mining will travel beyond the eco-sensitive area and cover an area up to the distance of 1 kilometer. Therefore, Lord, within 1 kilometer, no activities can be permitted. Lord, admittedly, in all the cases of the petitioner, Lord, the quarry lease area is within 1 kilometer. I have prepared a tabulation, Lord, showing the distance where exactly these leases are situated. May I reduce, Lord? The Lordship would say, all the lease areas are situated within 1 kilometer, that is within a distance of 505 meters, 32 meters, 485 meters, so on and so forth. The maximum is 740 meters. Committee is meeting, following the judgment of the apex court. Yes, strictly in accordance with it.
So they're asked to close and go back.
Lord, we have issued a notice to suspend the.
Lord, may I, Lord, before coming to these aspects of the matter, if your Lordship sees, my Lord, the impugned order itself, under what provision, my Lord, they have passed the order, your Lordship may kindly turn to Lord, Annexure E, page 126. Page 126, my Lord's court.
121.
126. 121. my lord, that is the operative portion of the order, 5/12/20. Yes, suspension order. In exercise of the powers conferred under Rule 8K2 of Karnataka Minor Mineral Concession Regulation 1994 I so and so, Mines and Gadak, suspend your stone quarry. My lord, I'll just pause here. Now, Rule 8K2, if your lordship sees under the Karnataka Minor Mineral Concession Rules. But why this becomes important is, on two earlier occasions, they had suspended on similar grounds of 1 kilometer, and this honorable court, my lord, had allowed and remanded the matter back. I'll point that out to your lordships, my lord, the earlier orders passed. But 8K says, quarrying operation to be in accordance with quarrying plan, simplified quarrying plan. Every holder of a lease license, working permission, sand tender shall carry out quarrying operations in accordance with the approved quarrying plan, simplified quarrying plan with such condition as may have been imposed under sub-rule 2 of Rule 8G or with modification, if any, as approved under sub-rule 3 of Rule 8G or in accordance with the quarrying plan, simplified quarrying plan, or the scheme of quarrying submitted or approval under Rule 8C or 8(1). 2. If the quarrying operations are not carried out in accordance with the quarrying plan, simplified quarrying plan as referred to under sub-rule 1, Deputy Director Senior Geologist concerned may pass an order for suspension of all or any of the quarrying operations and permit continuance of only such operations as may be necessary to restore the conditions in the quarry as envisaged under the said quarrying plan, simplified quarrying plan. Now, my lord, if your lordship sees on an earlier occasion, Lord, this honorable court, my lord, they had taken up the same contention. If your lordship sees Annexure B, my lord, an order passed by this honorable court. Annexure B, page 56. Starts at 56. My lord, if your lordship, my lord, turns to my lord, page 63, para 2, my lord, or relevant portion, my lord, at page 64. Paragraph 2.
Yes.
My lord, at para 2, my lord, on the next page, the first reason given in the said order is that in the meeting of the Gadag district so-and-so, it has agreed that it's necessary to stop the mining activities within 1 kilometer from the boundary of Kapatguda Wildlife Sanctuary. Therefore, the petitioner was instructed to stop mining activity. In addition, it was also directed to stop mining in the sanctioned stone mining leased area. On the last date, we had directed the learned additional government advocate to take instruction whether all the leases subject matter of these petitions are valid, subsisting. Today on instruction, he states that the leases are valid and subsisting. So, my lord, we are not doing any illegal mining, my lord, in these premises.
Yes.
Yes, ma'am. Then, your lordship may kindly then turn to para 5, my lord. In case the petitioners commit breach of the provisions case the petitioners commit breach of the provisions of the said rules of 1994 or the conditions in the leases, action can be initiated under Rule 6(3) of the said rules of 1994. Moreover, Section 19 of the Minor Mineral Rules Development so-and-so provide that if any prospecting license or maintaining or mining license is granted, renewed or acquired, so on and so forth, my lord, this writ petition was allowed. And if they had wanted to initiate any proceedings, cancelling or lease, my lord, they could have done so. Then, my lord, they again pass a similar order saying within 1 kilometer. Then again, my lord, your lordship may kindly turn to Annexure C. This is at page 67. Paragraph 7. We have gone through the rival contention of the parties. The respondent number 6 by the impugned resolutions called upon the petitioner to stop the mining activities. And based on the said resolution, respondent number 4 is also issued a show cause notice to the petitioner. Not in dispute that the petitioner submitted a reply at para 6 of so and so. The respondents have taken a contention that the authorities are yet to take a decision on the reply submitted by the petitioner. In the earlier round of litigation, the additional government advocate on instruction submitted, my lord, this my lord, the honorable division bench has extracted the earlier observation made. Held that district task committee or the state government have no power to close the activities of mining so long as the lease granted to the petitioner is valid and subsisting. The same cannot be prevented or stopped by the authorities. The impugned resolution, if examined, there is no change in factual matrix. In the earlier round of litigation, also similar contention was taken that the mining activities are within 1 kilometer from the boundary of Kapatguda Wildlife Sanctuary. In the present case, the respondent authorities have come with a case that respondent state has issued a draft eco-sensitive notification. My lord, now here there is an issue, my lord, because what, my lord, happens is, even for stopping, my lord, it is not the state government. It will be only the Ministry of thing, my lord, where the government, my lord, the state government can send a proposal. Based on the proposal, my lord, then an ESZ, my lord, an economic sensitive zone gets issued. An opportunity is given to us, and then, my lord, even in the Goa Foundation also, my lord, the Honorable Supreme Court said, there are so many people who are living, who are working. My lord, this is not a matter where we are carrying on illegal mining, my lord, and I'll just just continue. Unless there is an adjudication in regard to the license granted in favor of the petitioner, the respondent authorities have no power or authority to stop the mining activities when the lease is valid and subsisting. So, my lord, this order again, my lord, the writ petition was allowed and the matter was remanded. My lord, now again on the same ground they pass an order under Rule 8K2. And, my lord, now what the Honorable Supreme Court also, my lord, that what the learned government advocate read, my lord, there if your lordship sees, these are with relation to, in the same judgment, my lord. The first judgment which my learned government advocate relied on, Lord, I'll just point out a few things from that para 5. The present set of applications are right, Lord, may got it, Lord, that is page 553. T.N. Godavaraman's. This is just to give a context to why, my lord, the Honorable Supreme Court went. My lord, it is that internal page 553, my lord. This is 2022 10 SEC 544. In that internal page 553.
Yes.
Look, the present set of application arising out of a report of CEC dated so and so. This report specifically pertains to Jammu Ramgarh Wildlife Sanctuary. The sanctuary covers an area of about 300 square kilometers. The said report gives a horrific picture of ravaging of protected forests, mainly by private manors, mostly with temporary working permits obtained from the government agencies. So, my lord, then subsequently, now if your lordship sees, my lord, 56.1 at page 577. So, my lord, here one distinction, my lord, is that we are not, my lord, we are not on the property by any void document, or we are not illegally doing anything, or it is not that we have a temporary permit. What we are doing is legal environment clearance was taken earlier, my lord, before this lease was granted to us. Then your lordship may kindly see para 56 at page 577. Then your lordship may kindly take 56.1 at page 577. My lord's got that Supreme Court judgment 577, paragraph 56. That is the first judgment produced by the government. We have also produced that.
Para 55.
Yes, ma'am. No, yeah, I would request your lordships to take para 56. My lord's got it. 56.1. Each protected forest that's a national park or wildlife sanctuary must have an ESZ of minimum 1 kilometer measured from the demarcated boundary of such protected. Your lordship may kindly see, must have an ESZ of minimum 1 kilometer. So, my lord, everywhere, my lord, there is a mention of ESZ, my lord, environment session, zone, my lord. So this, my lord, is always there. So here, my lord, it has not been, ESG has not been issued as on today. Measured from the demarcated boundary of such protected forest in all the activities proscribed and prescribed in the guidelines so and so shall be strictly adhered to. 9/11, my lord, 9/2/2011, how it should be done, my lord, it is there. I have also produced a copy of that. Adhere to so and so. 56.2. In the event, however, the EAZ is already prescribed as per law that goes beyond 1 kilometer buffer zone, the wider margin as EAZ shall prevail. If such wider buffer zone beyond 1 kilometer is proposed under any statutory instrument for a particular national park or a wildlife sanctuary, awaiting final decision in that regard, then till such final decision is taken, the EAZ covering the area beyond 1 kilometer as proposed shall be maintained. The principal chief conservator of forest and also the home so and so shall remain responsible for proper compliance of the said guidelines as regards the nature of use with EAZ of all national parks, sanctuaries within a particular state or union territory, the principal chief conservator, so on and so forth. Then 56.4, mining within the national parks and wildlife sanctuaries shall not be permitted. That is, my lord, within the national parks. And this, my lord, now order has been subsequently clarified in the order passed by the Honorable Apex Court in the order, my lord, dated 26/4/2023. My lord, if your lordship sees in that, my lord, para number 61.
60.
No, that is at, my lord's got it, para 61. We are therefore inclined to allow the present IA. The direction in paragraph 56.1, my lord, which I read just now, my lord, to your lordships, in the earlier order, my lord, that is of 2022, this is of 23. 26/4/23. The direction in paragraph 56.1 of the order dated 3rd June 2022 is modified and clarified that the directions contained therein would not be applicable to the EAC, in respect of which a draft and final notification has been issued by the MOEF and CC, and in respect of the proposals which have been received by the ministry. My lord, if I may be permitted to pause here for a moment, and I am given to understand.
Where are you reading? Page 100.
Yes, ma'am. This is, my lord, para 61 of the order dated 26/4/2023. Lord, in fact, the government advocate on an earlier occasion, even in the matter here, my lord, first they said, we have sent a notification. Then they, my lord, and after hearing an interim order was granted by this honorable court, against which, my lord, they went to the Honorable Supreme Court. My lord, there the Honorable Supreme Court said, you are at liberty to file an application for vacating stay on the basis of which he has filed in vacating stay. There, my lord, they said that it has not been issued. Now, my lord, we are given to understand, my lord, that the cabinet has cleared the proposal, my lord, declaring this, my lord, with regard to 1 kilometer. So, my lord, once this is done, para 61 says, my lord, that we are therefore inclined to allow the present, the direction in paragraphs 56/1 is modified and clarified that the directions contained therein would not be applicable to the EAZs, in respect of which a draft and final notification has been issued. My lord, one, either a draft and final notification has been issued by MOEF and CC, and in respect of the proposal which have been received by the ministry. So, my lord, now if they do that, my lord, it will be only the central government, my lord, which can, my lord, then suspend or issue an order that it cannot within 1 kilometer. My lord, the state will have absolutely no power. My lord, because in the same judgment, if your lordship, my lord, turns to, my lord, if your lordship, my lord, may I request your lordships to turn to para 55, my lord, of the same judgment. Not because here the Honorable Supreme Court also talks about Rule 5 of the Environment Protection Act also. My lord, in para 55, my lord's got, in the same judgment 61, I just now read to your lordships, my lord, para 55. In so far as direction in paragraph 56.1, the order dated so and so is concerned, a perusal of various orders would reveal that this court has not directed any minimum area from the demarcated boundary of such protected areas. The area to be declared as ESZ cannot be uniform and will be protected area specific. In some cases, it may be 10 kilometers on one side and 500 meters on the other side. In certain cases, it may not be possible to have a uniform minimum area by virtue of interstate boundaries or a sea or a river beyond one side of the protected area. In any case, a detailed procedure, my lord, your lordship may kindly, my lord, mark this, my lord, in any case, a detailed procedure is required to be followed as prescribed under Rule 5 of the 1986 rules, which we have already referred here in above. We find that once such a notification is issued, after following the procedure prescribed under the 1986 rules, the ESZs will have to be as per the said notifications. It is further to be noted that as required under sub-rule 3 of Rule 5 of the 1986 rules, before any final notification is issued, a draft notification is required to be published in the official gazette and in such manner as the central government may deem necessary from time to time. Any person interested in filing any objection to such draft notification is entitled to file objection within a period of 60 days from the date of publication of the draft notification in the official gazette. We find that the central government can be directed to give a wide publicity to the draft notification so that all persons interested have knowledge about the issuance of such draft notification. So, my lord, there is a particular procedure which has to be followed. My lord, it cannot be the state, my lord, straight away without even a notification, without even a declaration of ESZ, can straight away come and say that within 1 kilometer you'll have to stop, my lord, because that did not have the power, which, my lord, has been held by this honorable court on 2 occasions. My lord, then para 57. Pertinent to note that after following the aforesaid procedure, the matter is placed before the expert committee consisting of 13 organizations having expertise in the related field. As such, before an ESZ area specified, various factors are taken into consideration. Your lordship may kindly mark this, my lord. Before an ESZ area specified, various factors are taken into consideration. There are various factors which will determine the ESZs for a particular protected area. The circumstances may differ from one protected area to another protected area. As such, we find that the direction which prescribes a uniform 1 kilometers required to be modified. It is further to be noted that on the date of filing of the present application, final notification have been issued in respect of 474 protected areas. My lord, their final notification was already issued. Here, my lord, all these things have not yet been done. Then if your lordship sees the last order, my lord, which was passed just 2 days after this order, 28/4/2023. My lord, your lordship may kindly turn to para. My lord, they have referred to the earlier observations, my lord, that para 13, my lord, para 13. Paragraph 13. Order of the Apex Court dated 28/4/2023. It should be the last judgment produced by the government. The last of the judgments, my lord, which she was relying on.
Para 13.
Yes, para 13. My lord's got. Para 13. It will further be relevant to refer to paragraph 66(1) of our judgment dated 26 April 2023, which reads thus. The MOEF and CC and all the state union territory government shall strictly follow the provisions in the said guidelines issued dated 9 February 2011 and also the provisions contained in the ESZ notifications pertaining to the respective protected areas with regard to prohibited activities, regulated activities, and permissible activities. It could thus be clearly seen that we have directed the MOF as well as the state government shall strictly follow the provisions in the guidelines issued, as also the provisions contained in the EAZ notification pertaining to the respective protected areas with regard to the prohibited activities, regulated activities, and permissible activities. Then, my lord, I will then take your lordships to paragraph 24. Lord, this may have some significance, my lord, because the prohibition of 1 kilometer from the boundary of protected area is only with regard to cases where the boundary of ESZ is less than 1 kilometer from the boundary of the sanctuary. Only in such cases, the ban on mining will travel beyond the ESZ area and cover an area up to distance of 1 kilometer. So all these matters, my lord, your lordships have seen, all after the final notification where, my lord, eco-sensitive zone has been, my lord, issued. Now here, my lord, even, my lord, assuming all these quarrying, my lord, comes within a kilometer. My lord, now the government has sent a proposal. My lord, rule, if your lordship sees, my lord, the environment protection rules, my lord. Rule 5. Rule 5, my lord, this is, my lord, it prescribes as to how ESZ, my lord, eco-sensitive zone, my lord, has to be done. And this is what has been extracted by the Honorable Supreme Court in those paragraphs 55, 56 onwards. Beg your pardon? Yes. Yeah, 26.4 order. My lord, with regard to the provisions or with regard to the para 61, my lord, which says para 61, my lord. Yes, ma'am. That is at my lord, if your lordship sees para 55 onwards, para 56, your lordship may kindly see para 50. It's further to be noted that as required under sub-rule 3 of Rule 5, my lord, which I was trying to point out to your lordships, my lord, under the environment protection rules. Sub-rule 3 of Rule 5 of the 1986 rules, before any final notification issued, a draft notification is required to be published in the official gazette and in such other manner as the central government may deem necessary from time to time. Any person interested in filing any objection to such a draft notification is entitled to file objection within a period of 60 days from the date of publication of the draft notification in the official gazette. We find that the central government can be directed to give wide publicity to the draft notification so that all persons interested have knowledge about the issuance of such a draft notification. It's pertinent to note that after following the aforesaid procedure, the matter is placed before the expert committee consisting of 13 organizations having expertise in the relative field. As such, before an ESZ area is specified, various factors are taken into consideration. There are various factors which will determine the ESZs for a particular protected area. The circumstances may differ from one protected area to another protected area. As such, we find that the direction which prescribes a uniform 1 kilometer requires to be modified. So then, my lord, that's how they proceed further. So this Rule 5, my lord, prescribes as to how it is to be done. My lord, here, my lord, indisputably, my lord, the government advocate also said, my lord, that ESZ has not been issued. My lord, the government now, my lord, has sent a proposal. Once, my lord, the government sends a proposal, my lord, this is, my lord, I must, at the outset, my lord, bring it to your lordship's notice my lord, that this mining is legal and lawful, which is being taken, undertaken by the petitioners. There have been no violations. In fact, on the earlier judgment also, my lord, 3/6/22, this rule 5 has been extracted by the Honorable Supreme Court in para 29. So, my lord, my contention to your lordships, my lord, is that, my lord, even after this also, my lord, what happens is they say, my lord, that that even then it has to be done in a phased manner. My lord, it cannot be, my lord, the state government, my lord, has no power, as held by the Honorable Division Bench, my lord, on 2 previous occasions. If there's any, my lord, we are doing legal mining, my lord, after getting all the environment clearance. Their only case is 1 kilometer from Kaputguda Wildlife Sanctuary, my lord, which till today, no EAC has been issued. My lord, if that is done, my lord, once the proposal goes, my lord, we have absolutely no objection. If your lordships were to direct them to complete this process within any particular period, my lord, we have no objection. We will file our objections, we will go there. My lord, in fact, my lord, when so many people are working, my lord, suddenly, my lord, it cannot be stopped, my lord. There also they say after all this, they'll do it in a phased manner. My lord, the state government, my lord, would have no power. My lord, the central government, my lord, has the power to do it. If the state government, they may want, my lord, they can say that is under section 3, my lord, of Environment Protection Rules. Section 3, the central government has the power. Power of the central government to take measures to protect and improve environment. Subject to the provisions of this act, the central government shall have the power to take all such measures as it deems necessary or expedient for the purpose of protecting and improving the quality of the environment, preventing, controlling, and abating the environmental pollution. So, my lord, if the central government so wants, my lord, then they can, my lord, immediately stop, my lord, us or saying that within a kilometer. And this, my lord, the Honorable Supreme Court themselves, my lord, on 2 orders, my lord, have clarified that where there is already a proposal which is being sent, then this would not apply. My lord, it is understandable, my lord, why the Honorable Supreme Court has said that is, once a proposal goes, my lord, then it is the machinery set in motion, where, my lord, they will issue a notice to us and we are supposed to reply. Then a final notification is issued. And then, my lord, whatever action, my lord, in a phased manner or whatever they do. In para 36 also, my lord, does. There also, my lord, in that.
My submission, sir. This is a quarry lease, which is a minor mineral granted by the competent authority of the state, and state has the power to grant or cancel the mining lease, quarry lease. The submissions of the other side that the state has no power is baseless. My submission is
State has the power. My lord, what he is saying is not right. I'm not saying state does not have the power. State has the power under the minor mineral rules as held by this honorable court. My lord, if there is any violation.
No,
but the state does not have the power to suspend on the ground that it is 1 kilometer within the national park, even without any notification, even without any ESG being notified. That's our submission.
My submission is, Lord.
Lords, I am in item 57 point. Petitioners, my lords. I would only submit this. They have issued an order, my lord, saying that they will cancel if I don't get clearance from NBWL. Now, in view of these orders of the Honorable Supreme Court, I'll say, my lords, we'll have to stop. I will stop. But we'll approach the NBW, that is National Board of Wildlife. Till then, let them not cancel, my lords. That's the only thing. Because they have threatened that they will cancel.
We have
Suspended.
That's all.
My lords, because of an interim order, my lords, my lords, we can, in the teeth of this, I know my limitations.
There is a clear prohibition by the
That's all I am.
board. Whether the eco-sensitive zone notifications are issued or not, it is of no consequences at all. There is a clear prohibition to conduct non-forestry activities within 1 kilometer of the eco-sensitive zone is the last order passed by the Honorable Apex Court. May I read, my lord? So it is. page 100,
Any clarification, problem is, there is an observation by the Honorable Supreme Court, so I'll stick to that. and say
112, please.
not
112,
do anything.
para 24. 112. The prohibition of 1 kilometer. Prohibition of 1 kilometer from the boundary of protected area is only with regard to the cases where boundary of ESJ is less than 1 kilometer from the boundary of the sanctuary. That is in a case where eco-sensitive zone notification has been issued, wherein it is delineated within 1 kilometer. Even in those cases, 1 kilometer has to be maintained is the clarification.
But
Then,
that arose because of a clarification sought there, my lords. What
only
happened?
in such cases.
ESZ was more than 1 kilometer, so somebody filed an application seeking clarification that ESZ can be only for 1 kilometer ban. We should be permitted because our area is more than 1 kilometer. That the
And-
Honorable Supreme
and-
Court clarified,
Yes.
saying minimum is 1 kilometer, beyond 1 kilometer if it is ESZ, that's the
And
clarification.
my lord, the Honorable Supreme Court also says there cannot be a uniform thing.
That-
It can be 500 meters, it
But-
can be 10 kilometers also.
That
So
they'll
we have not, the Supreme Court has said, we have not said demarcating it as 1 kilometer anywhere. My lord, that I read out to your lordship. Lord, and one more thing, my lord, is we had a
I'll
protection
complete.
of after hearing the matter, my
I'll
lord, this
complete the
Honorable
reading.
Court granted an interim order.
Further, in the same para.
My lord, then
Lords, there.
Only after they have notified. Has been notified. One kilometer.
Para 60, my lords, in 26th April order, they made it applicable pan-India. That was actually for Goa, that they made it applicable.
my lord, those were where I had,
only
my lord, read out, my lord, ravaging, my lord, illegal mining, temporary permit, my lord, where they were ravaging the forest, my lord, but here is not, and my lord, this Honorable Court, my lord, as he is, my lord, to some extent, he is, my lord, the connected petitioners, my lord, all that I would say, my lord, is this. My lord. We had, may I just make this submission?
Not that I'm
My lord,
against
this
him,
on-
but my lords, not that I'm against we are sailing, but I know my limitations, my lords, that's why I'm.
My lord, all that I am saying, my lord, is, my lord, earlier 2 occasions, my lord, this Honorable Court allowed our writ petitions, remanded the matter. Here, my lord, after hearing both of us, interim order was granted.
No.
Against that, yes, but Supreme Court did not,
that's it,
my lord,
that is
vacate the
exactly-
interim order.
Correct.
They challenged the interim
Before
order
the
passed
Supreme
by
Court
this
order.
Honorable Court before the Honorable Supreme Court. The Honorable Supreme Court said, will not interfere. If you want, you file an application for vacating.
In
So
those-
that's how, my lord, he has filed an application for vacating that interim order. That's how,
In
in
those
the orders
cases,
matter, it has
these
come before.
orders are not brought to the notice of the honorable bench. And
They have filed it, my lord, before Supreme Court and they're saying they're not brought it. They went to the Honorable Supreme Court. The government goes, my lord, and the government now is saying this was not brought to the notice of the Supreme Court. I fail to understand as to.
I'm sorry, not to the Supreme Court. The earlier judgments, in those earlier judgments, these orders are not brought to the notice of the bench.
Lord, when an
And one-
interim order was passed by this Honorable Court, my lord, he says these were not brought to the notice. When they go to the Honorable Supreme Court where all these orders were there, my lord, the Honorable Supreme Court refused to interfere with the order passed by this Honorable Court.
One more submission I would like to make.
Yes.
But see,
One submission.
their problem arose only because this was declared as a wildlife sanctuary after our leases were granted. That's how.
Beg your- Yes, where we are.
One,
Yes.
one last submission I would like to make.
No.
Yes.
That, my lord, is what the Supreme, we have not said, so the Supreme Court says.
One last submission I would like to make. In absence of eco-sensitive zone notification, that issue is covered under 56.8, wherein the apex court says wherever the eco-sensitive zone notification is not published. Not in those cases, 10 kilometer has to be maintained, not 1 kilometer. 10 kilometer, 56.8 in the first judgment.
That is clarified in 28/4. But that has been clarified in 28/4/2023 after 2 days.
10 kilometer has to be made.
Yes, ma'am. Please, we'll give them. Yes,
Please.
we understand.
We shall file tomorrow itself.
It will not be, my lord, now it's already, my lord, to give this, my learned friend may be very efficient, my lord, but we are not so. So we'll need some time.
Please, short point is involved in this.
Yes.
Till them, let them not continue the lease, my lord, because.
The interim order is there in our favor. Supreme Court did
Quarry
not
is going
interfere.
on.
Now he wants it to be
Quarry is
vacated.
going on, my lord, within 1 kilometer.
Yes, my lord, interim,
They
and
are
Supreme
protected
Court has
and-
refused to entertain their prayer. No, my lord, the Supreme Court did not interfere with the order
It
passed
is-
by this court.
No, it is an incorrect
Lord,
submission.
I have the copy of the interim order, my lord. I don't know
That
why.
Apex
I have
Court
the copy
only
of the Apex
said,
Court order.
you file an application for vacating stay by
Yes.
affording an opportunity to them, let the bench consider it.
Yes, ma'am. So
It
that
is
is the
not
reason
that
why I am
they have
saying.
refused to.
Otherwise.
No, I have produced along.
Go back to the same.
That
court.
is what.
So, my lord, that's how
Supreme
he
Court has
is.
not refused it.
No, my lord, what we are saying is your lordships are having it in a few days. We are already protected.
Yes.
No. What I'm saying, my lord, is my lord, the Supreme Court did not grant any order. They did not set aside the order passed by this court. The Supreme Court said you go back. My lord, they have filed an application for vacating. Now, why I'm saying that is since your lordship said that your lordships will have it on 20th. All these years, my lord, for 3 years, we have been protected by this honorable court. My lord, 2 by final orders, interim orders, and even interim order till today. So only till 20th, my lord, we may be protected till your lordships decides the matter.
Concession.
They have filed an application for vacating. We have filed our objections to that. Beg your pardon.
Within 1 kilometer. 500 meters, 30 meters, the quarrying is going. Exactly for the reason, Lord, till let them stop for period.
My lord, your
Till
lordship
your
may
lordship
hear and
takes a
pass final orders, my lord. Till then, we may be protected. All this while we have been protected, my
Lord,
lord, 3 years.
The
My lord, by this
damage
honorable
to
court.
the environment cannot be reverted. That's my submission.
Please. Oblige.
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 Lords, I appear on behalf of the appellant in this matter. Well, I appear on behalf of the appellant in this matter. I had filed an IA for early hearing, my lord, so date may be fixed for hearing. Please. The matter was adjourned to today for fixing of a date. Please, move.
As the date may be fixed, I'll make my submissions. Last week of March means. Obliged.
I appear as the amicus in the matter, my lords.
Which you are under challenging.
Yes.
Till the receipt of the trial blasting report, the land cannot be used for. So now what is the stage status?
Lad, what happened was, lad, this court, lad, took, lad, this writ petition, private interest as a public interest, lad, directed that there shall not be a quarrying activity within 20 kilometer till the trial blast is conducted, lad. Now the trial blast, lad, is going on. That's what we have been informed, lad, where earlier there was already a, the scientific study was conducted, lad, when the quarrying activity is done with using blasting material, how it affects. Lad, so far as the present land is concerned, lad, is about 12 kilometers from the KRS dam. So now this court, lad, directed that there, till the scientific study is conducted, there shall not be quarrying activity within radius of 20 kilometers. Now, all those applicants, they are who are affected by the order of this honorable court, they want to come as the respondent before this honorable court, those applications. There is another application filed by me, before lordships. The order of this honorable court is only with regard to the conduct of quarrying operations within the area. Now, by making use of this, they have even stopped the stone crushers also, Your lordships are aware, stone crushers, they use a building stone purchased from the quarry leases outside, and they conduct the crushing activities they don't use any blasting material. Now the state government, their deputy director of mines and geology, stop even the crushing activity also. Therefore, I have filed that application to clarify that, that this order is applicable to the quarrying operation using blasting material. The safety of the KRS dam will get affected only when, there is a quarrying activity by using blasting material. The conduct of crushing operations, will not affect the safety of the dam at all. And on account of this, a large number of people are affected. I have produced one of the copy of the order before Lordships, wherein the senior geologist has passed an order directing stopping all the crushing activities in 20 kilometers, affecting lakhs of people. All these people have invested huge amount of money and established their stone crusher unit. 8 to 10 crores they invested on each. And they have electricity connection, paying minimum consumption charges. They have employed large number of workers. So your Lordship's order is very clear, They are using the word allied activities.
Lords, may I submit as the amicus in this matter, my lords?
So far as IA number 2 is concerned, I have filed seeking for impleading in this petition. The reason is I am having the leasing license from the government for quarry in the multicolored granites, which do not involve any blasting at all. It is only by drilling and then taking out the slab. Since it is a slab, I cannot blast it. If I blast it, then I cannot extract the slab. So my activity is also affected because of this interim order. Therefore, I want to express my difficulties and the hardship I am facing.
Lords, may I submit, my lords, as the amicus?
Interest litigation has been taken as a PIL. Sri Aditya Sonti
Learned Senior Counsel.
has been appointed
Lords,
as amicus in this
I appear as the amicus in this matter, my lords. I hope I am audible to your lordships.
Yes, sir. Yes, sir. Go ahead, sir.
Yes.
My lords, by your lordships, order dated 8/1/24, after para 9, the direction issued is, my lords, in 2, the prohibition of mining or allied activity. Therefore, any activity, my lords, which poses a threat to the KRS dam has been prohibited, my lords, till such time the statutory committee under the Dam Safety Act presents its report. Now, my lords, whether the activities of these respective applicants poses such a threat to the dam or not is something that the expert committee under the Act, my lords, would have to examine. Therefore, your lordships may direct that these applicants before your appropriate representations before the committee which comprises experts can then place before your lordships whether such can be permitted or not. Otherwise, my lords, it would open up a Pandora's box. My learned friend, Mr. Chidanandaya, in fact, is made an application on behalf of some of the other parties, affected parties who are not even before the honorable bench. So it's in view of the larger public interest, my lords, that this direction was issued.
With all due respect to the Lord amicus, this court intended to protect the KRS dam by conducting quarrying operation using the blasting material. In fact, my lord, I have placed before Lordships, my lord, a Government of India organization, my lord, National Institute of Rock Mechanics.
That's now the committee is already.
I'm given to understand, my lord, that the committee has met today. I'm given to understand that the committee is meeting today and the meeting is under progress, actually. So they are identifying the locations where the trial, I've filed an impleading application, my lord. I am the complainant.
You are for committee.
No, my lord, I have filed an impleading application, IA number 4 of 24. I am the original complainant who filed the complaint because of which all these issues were propped up. Now the issue is not only about the safety of the dam, my lords. What is happening is because of the quarry activities that is being carried out, all the water that is being found under in all these areas are being drained into the Quarry rivers, which is virtually polluting the water. So there is an overall environmental threat to the entire this one.
Which activity?
I really do not know.
My lord, in the quarrying activities. So it's not only about the safety of the dam, my lord, it has got lot other repercussions. So therefore, I had originally made a complaint.
Activity of all yours are mining activity.
My lord, I'm not carrying out any activities there. I'm a resident of the locality who filed the complaint identifying that these activities, illegal activities are being carried out. It's based on that, my lord, the issue developed and condition number 8 came to be imposed.
And
And
it is not correct, my lord. It is not his, my lord. In Mori's cases, my lord, these are all, my lord, where they are only claiming to be right information activists, creating problem for all of them, my lord.
And the committees.
My lord, dam safety committee can take a decision. So far.
Committee is undertaking what kind of exercise?
my lord, they are identifying the locations
My
where the
lord,
trial
my lord,
blast can be
government
taken
advocates
All of you may
say, my
go.
lord, it's
All
not
of you
the
may go.
complainant, my lord. The
Yeah.
government advocate should say.
Lordship, may kindly see, the modalities proposed by me, the way of carrying is already approved by the government. There is nothing, no water is this one, there is no blasting material in water.
So
In
the
my kind of activity,
committee
because
is
it
to-
is slab, it is not a blasting.
Committee is to submit report here.
Yes, my lord.
There
In
is
view
a-
of order dated 8/1/24.
But there is a-
Permit all of you to go before the committee and make
May I
representation.
submit, my lord? There is a dam safety committee, my lord.
Instead of impleading yourself here,
Yes.
you ventilate your grievance there and report will be.
As rightly submitted by the senior counsel, Lord, senior amicus. Lord, dam safety organization is in place, safety committee is in place. Lord, they are the authorized bodies.
No, there is an expert committee. There is one expert committee from Pune,
Who
is
is
appointed.
That is
anybody,
to conduct.
who is for the committee?
R5, who is representing R5, sir?
Committee will be government advocate only.
Committee I am representing.
You are.
Well, let them take
No,
a
I have-
decision with the
I
time
have
frame,
filed
right,
a
so that.
detailed statement of objections on Lord 5th December 2023.
So you as a committee are ready to
Undertake Lord.
no, listen to the grievances of all those who are wanting here to be, we will not permit here in
Please,
any implement. You go before the committee.
please.
And whatever you
them-
say before the committee will be reflected in the report of the committee to be submitted to before this court.
Now, what happened is in this matter, my lord.
Yes, brother is right. The last direction implicitly says that only.
Yes.
You go before the committee.
No, what happened here, lordship, your lordship may kindly see, there is an expert report is awaited from Pune, some expert agency.
That is.
That
so
is
far as
what
the
this
trial
government
blast
is
concerned.
waiting. For us, now 2028 is the last date up to which I can carry out. I have already committed for exporting these granite slabs. Now I am losing a tremendous financial loss because of this order, which is total ban. So let them, I am ready to go before any committee or any.
How many implement application is there?
One, I have filed one application.
Only two of
So
them.
go
Only
I have
two
filed, I am the
applications are-
complainant, my lord. I have filed one
My
application.
lord, I have a
So you
serious
can also
objection
go
for
there.
the complainant, my lord.
Liberty may be revoked.
No, that may delay more this one. Your lordship may
He has
kindly
not
see
even
the my
served a copy to
situation.
me.
I've already invested money and I have already committed for export where foreign exchange
The
is also
council
involved.
bleeding you right now readily here will in a way complicate the thing.
Yes.
My lord, may I submit one thing, my lord?
May I request,
Submit
my
one
lord,
thing, my
one
lord.
alternative, my lord?
My lord,
Let the government get the earliest the report from the expert committee. What is the activity which is really causing harm to them? Because that is very much necessary to see any harm caused to the dam. That has to be, that such activities has to be banned. But for the committee furnishing the report and government placing that report before the court itself is taking time.
Hmm.
That is causing tremendous loss to the persons like us.
let the government advocate submitted that your lordships have recorded, my lord. Within 6 months, my lord, they will conduct the trial blast and take a decision. My lord, if they take a decision, my lord, first the trial blast will have to be conducted. That has to be placed before the dam safety organization. Then they have to take a decision. My lord. Whatever the decision they take, my lord, it will be binding all of them, my lord. If they take the view, my lord, yes. If they take,
1 minute. Para 20 of my statement.
We will pass the order relegating the implement applicants to go before the committee.
Lord, based on this, Lord, para 20 also a direction may be issued.
Para?
20 of my statement of objection.
Where is that?
5th December 2023. We have filed.
Page 15 of the objection.
Para 20.
Page 15 of his objection.
Here there is no system of running pages here.
No, they will file running page for a separate.
Running page 15.
This one.
So which paragraph? 20.
20. It is submitted that to undertake trial blasting afresh, the following time period is required for preparation of trial blasting. The experimental blasting and monitoring of ground vibration and for submission of the draft report to Quarry Nigam. Then Lord, A, the explosives, blasting accessories and drilling machinery should be arranged initially for the experimental blast. Once the requirement for the experimental blast are ready, drilling of holes will be carried out under the supervision of CSIR, CIMFR team. Mobilization of men machinery with preparation work 1 month is required. So also, once the drilling holes are completed, the amount of explosives and blasting accessories required for experimental blast so on. So timeline is not provided in under para 20.
Yes, that's what is.
So you want to go to committee about? No, what, Mr.
Government advocate.
Government advocate, what is your submission?
My submission is, Lord, within this period, we are going to conduct trial blast experiment. And then submit a report to this.
They submit, my lord, now.
Report to the committee.
They have, if this time frame is fixed, my lord, then every problem will get resolved. And what government advocate says, my lord, within 2 months, my lord, if they conduct trial blast, take a final decision, my lord, it will be clear, my lord, whether the conduct of quarrying operation will affect the safety of the dam, my lord. The experts will take a decision. Once the expert take a decision, my lord, then the writ petition can be disposed of on the basis of the decision of the expert. And now the problem is, my lord, now the trial block is going on, my lord. There are many organizations like while the pleading applicant, my lord, are creating a problem, my lord. They're using in the name of Raita Sangha, some organizations, they are protesting, they are not allowing this, the trial blast to conduct, my lord. That's what every day it is coming in the newspaper also. They are going and obstructing the people in discharging their duties. And therefore, my lord, Deputy Commissioner, is a district collector, my lord, should take a firm decision to deal with these elements and conduct a scientific study as your lordship directed.
Till committee report come.
No, that's to come to that committee report, my lord, they have to conduct trial blast, my lord. Some of these organizations are not permitting to conduct trial blast.
In my activity, my lord, now they are conducting a trial blast. In my activity, there is no blasting at all. That is the difficulty I am facing. Only because trial, where blasting activity is involved, there this situation is there. Where blasting itself is not there.
The report is published, not submitted. It will give pointers to all the issues.
Unless this report comes, committee can't take any decision.
Yes.
And moreover, even that report, when there is no blasting involved, that report will no way either help or touch my activity, my lord. That's why at the most, the government advocate may be directed to see my activity and submit a report to the court. Whether through his officers,
No,
I
it
mean,
is only the
whether any blasting activity is involved in my activity. If it is not there, only those categories of activities may be permitted.
So far as the prayer main is covered by a division bench judgment, but this is treated as the public interest litigation, I am In fact, my lord, if your lordship see along with rejoinder,
Because as per the interim order,
Noticing the controversy in course of the hearing, the petitioner seeks to have the quarry license under the provisions of the Karnataka minor mineral concession rules. The application was moved by the petitioner to the Tehsildar, which was processed at various stages under the rules. And at the stage when the petitioner was called upon to make payment of conversion fee, the order came to be passed on 15th. Office memorandum came to be issued on 15/5/23, in which one of the condition imposed before the condition imposed to be complied with before the quarry could be commenced was condition number 8, which read as under page 28 over. On page 28, condition number 8, quote the condition. The controversy in this case centers around the aforesaid condition number 8 paragraph. The proceedings of this writ petition witnessed different orders from time to time, including order dated 8/1/24, wherein the coordinate bench, after noticing the rival case and contention, issued the following directions. Then reproduce the directions, which is in order dated
Direction 1 to 5.
8/1/24, direction number 1 to 5. When the petition comes up for consideration today, it accompanies 2 interlocutory applications by the third parties who wants to implead themselves in the process, who prayed before the court to permit their impleadment in these proceedings. Their contention is that the directions issued by this court in aforesaid directions in order dated 8/1/24 issued by this court adversely affects them, as according to them, they have no concern to the controversy,
and there is
and
no
that they are
blasting
entitled
activity.
to carry on their mining activity.
Mining activity, but without
Mining
blasting.
activity.
Quarrying activity without blasting.
Full stop. They contend that without compliance of condition number 8, namely the trial blast conduct, they could be permitted to continue with their business activity. Full stop. There is also some controversy about the scope and import of into one comma allied activities mentioned in direction number 1 of the aforesaid order. Be as it may, full stop. It is noticed by the court that the committee called
Dam Safety Organization.
Yes.
Respond.
the state level dam safety committee is constituted or is committee?
Is
It is
constituted.
Is constituted. Full stop. The said committee is arraigned as respondent number 5 in the writ petition. Full stop. The committee is seized with the entire controversy pursuant to the aforesaid directions issued by the court in order dated 8/1/24. And the committee has been examining the issues involved in the controversy and the attendant aspects threadbare. Full stop. The committee is also giving hearing to the interested parties and has been taking into account all other relevant considerations. Full stop. The committee, it was stated by government advocate, Mr. Mahendra, that the committee would submit its report after undertaking the necessary inquiry into the all aspects. He further submitted that further submitted on the basis of the counter affidavit filed by him. Where is that?
Para 20, my lord, page number
Statement of
15.
That the experimental blasting would have to be conducted time bound. Full stop. In this regard, he invited attention of the court to the contents of paragraph 20 of the counter affidavit. Paragraph. It reads as under. It is submitted after quoting. It is written A is written. There are 15 of the counter reply. It was submitted that undertaking of blast
Trial blast.
would require extracted. Full stop. The aforesaid shows that for different at different stages, time lag is required. The total time period indicated is 3 months.
6 months.
6
total
months. 6 or 3.
Correct, yes, 2 months plus 4 months, yes.
4 months, my lord, plus for submission of report to the CISR, CIMR, they have to place it before the
My lord, in your lordship's order dated 8/1.
4 months. Not to take a decision on the report, they'll take 2 months.
My lord, in fact, on 8/1/2000.
Outer limit, my lord, maybe.
You can cut short this.
You are submitting report, why required 2 months for Kaveri Neeravari Nigama, sir?
That is what my instructions.
Led, in fact,
Your engineers will give all kind of instructions.
led in November, he said he.
While total 4 months is indicated as above, the court is of the view that the entire exercise should be completed within
15 days.
10 weeks, 2.5 months. And thereafter, the report shall be submitted to the court, which will be utilized in adjudication of this case and the controversy. Also, the report shall be submitted. The entire exercise, including the submission of report, shall be completed within 4 months.
Yeah,
Full stop.
submitting the report, let them consider
The
the
present-
activities which are not,
Full stop.
blasting activities
As far
not
as the-
involved.
As far as the prayer of the impleading applicants in the interlocutory applications are concerned, it is observed that the interested they as an interested party are entitled to approach the Municipal 5 committee to put forward their case, which in turn shall be considered by the committee. Full stop. Learned government bidder submits that if proper application is made by such applicants, the committee shall appropriately deal with their case on merits and incorporate the same. Incorporate the said details in the report to be submitted. Full stop. Put up after 4 months. 4 months is too long.
Led, 4 months.
4 months is required, my lord. That's
Already
paid.
4 months happened.
Let
We give 2 months and then you.
The trial
So-
box is already, they have.
So
they have
put up
started.
after 2.5 months, 10 weeks we have given to complete the blasting.
The trial blast is already underway.
We'll list this, list the writ appeal, writ petition in the reopening of the, when the vacation year will
May
go,
29th.
May 27th.
28th of May.
Public.
So on that day, we may seek time, you may seek time to.
IA1, my lord, your lordship may, there are other writ petitions filed. Your lordship may permit me to withdraw that IA to hesitate in the number of writ petitions we have filed. Where is
A
the
number?
IA number? 1 minute.
I number one, separate order, I'm saying. I number is permitted to be withdrawn. Last line. Learned advocate, Mr. So-and-so, 6% to I number so-and-so, permission is granted. IA is dismissed. Is withdrawn.
Obliged.
Permit to withdraw the appeal.
Which one? 50?
Filing a memo to withdraw the appeal, my lords, has not pressed.
Withdraw. Man, I interlocutor.
53. Learned advocate, Mr. S.H. Raghavendra.
S.H. Raghavendra.
Tenders the memo for withdrawal of the appeal on behalf of the appellant and seeks permission of the court to withdraw the appeal upon instructions. Full stop. The permission is granted, the appeal stands dismissed as withdrawn.
Yes,
The memorandum, the memo for withdrawal shall remain on record of the case.
Yes,
In record.
Pending IS discord.
Pending interim applications will not survive in the withdrawal of the.
I appear for the appellant, my lord. This is again connected with the,
Connected number could.
my lord,
I may.
my lord, I may be permitted to make two submissions, my lord. Nearly 30 writ appeals have been filed. All of them are similarly placed. And in all these cases, the interim order has been granted, and it's a very limited order that the government shall not precipitate the matter. Therefore, the benefit of the interim order should be granted to me also, ma'am. Number one. Number two, the government itself has submitted that they are not going to precipitate the matter.
Notice has not gone.
I'll undertake to file my wakalat for R1 and 2 minutes. Because I have the petitioner before the learned single judge.
GA text notice to R3.
R1 and 2 minutes.
2nd of November, my lord had directed me to take notice for respond number 3.
No, this is
Notice
coming
is
first time, madam.
This is coming for the first time.
There is no order earlier passed.
You will appearance to undertaking. So on.
KB Narayan,
to
sir.
appear for the R1 and R2, GA undertakes to file, undertakes notice for R3. What about the delay, madam?
My lord, all the appeals, it is similarly circumstanced, my lord.
Counsel for the R1 and R2, GA have no objection for condoning the delay. Submission placed on record, IA 2/24 is allowed, delay of 96 days is condoned. Full stop. Service complete and post along with number of you.
On 14th month.
Interim order,
14th, 23 October.
same interim order as passed in the main matter. Yes.
My lord, yesterday, this order was not passed in, I will give the number, kindly, the same order may kindly be passed in that order also. Yesterday, your lordships did not grant me the interim order.
My lord, I am before my lord, If there is
delay was not
anything,
condoned, that is
then
the
I will
reason why
make
it
a
was not
submission.
My lord,
I don't know why
my lord-
such a submission is being made. We are not precipitating, we are not doing
that may be
anything.
recorded, my lord, that may be recorded.
No,
Don't
not
record
that.
It's already
Now
recorded.
yesterday's matter is gone.
Let him come on an affidavit to say that this is what we are doing, my lord.
My
Now
lord,
don't want to do-
I was only bringing to the notice of this honorable court, my lord. I was only bringing to the notice of this honorable court, the
Yesterday's matter
submissions made by the,
Yesterday,
Delay. There was a delay. That's the reason why.
there was a delay in each and every application, my lord. It's not only in this, every appeal it is there. It's similarly circumstanced.
Anything you please come, we will take it. Don't worry.
It is only the particular appellant feels like that, my lord. I am only
Incident
expressing the feeling of the appellant here.
Grant one interim order in one case, it should be passed in all the cases.
That is not the case, my lord. I am only talking
The
about
government is
one
making a
particular
response-
appellant who has been not granted this. Because
What
the
is-
appellant feels left out. That is what I am trying to bring to your lordship notice.
My lord, we are all responsible officers of the court.
I never, no, my lord, my submissions were nothing to do with the responsibility of the government.
No, your submissions are that.
No, certainly not, my lord.
Sir, your
That is not the
case
way.
is over,
That is not
sir.
the thing.
No more discussion.
55.
My lords, 55, I beg to appear as the amicus. This is a matter, my lords, pertaining to proceedings against MPs and MLAs. Pursuant to your lordship's direction, my lords, on 10/1/24, the learned registrar has filed a status report. If your lordships give me about 10 days to study the report and then respond to this, I would be obliged.
You have seen the RG report, sir? The report.
You have the report?
Yes.
Recent.
Report ಇದೆಯಾ?
Involved in criminal cases.
ಇದೆಯಾ? ಅವ್ರು ಯಾರಿಗೆ?
Further report has to be fresh report. ಇದು ಹಳೆ old.
It's being opened now. ಅದು ಕೇಳಿರೋದು.
Sir, Sondhi sir, have you seen that latest report?
My lords, kindly give me some time to respond to that report, my lords.
Very good.
Sir, had amicus curiae, the report of the register, report dated 27/2/24 is placed on record.
My lord, the
But of the
copies,
learned,
copies may be supplied to us, my lord. Copies of the report.
Learned amicus seek time to peruse the report and office of the RG shall furnish the copy to the learned amicus and also the government and all the advocates appearing on that.
Obliged.
Great.
my lord.
I'm grateful to your lordships. Grateful.
Yes.
Can go in the second week of
Yes.
April.
Please.
April.
Second week, huh?
Second week April.
10th of April. December 56. PB
That's, there's a continuation of delay application.
for the government,
It's a
my lord.
delay of,
62 days.
in the first matter, madam, lots in
Complete,
56, serial number
service
56, there is a
complete in
delay.
all the cases?
In one case, it's not complete, my lord, serial 56.1. The service insofar as respondent number 32, respondent number 34, 36, 38, 39, 40 and 41 is not complete. Who are respondents number 6 in the writ petition, 9 is been represented. Respondent number 6, that is respondent number 32, though service was served on them in the writ petition, they did not appear and there was no representation, my lords. My lords will find it in page 28 of that writ petition. My lords, for a minute, my lords should consider page 28 of the writ petition. Page 28 of the compilation, my lords. My lords should see notice to R4, page 28, my lords. Sorry.
You go one by one.
Please.
Take first 56.
In
Ajit Kalan, you have any objection to IA1 of 22, sir?
Could be.
56, Madam Barkoli. Full stop. Shri Ajit Kalan, Learned Counsel for the respondent and also Learned Government Advocate. You have no objection to IA1 of 22.
56.2 also, there's only condonation of delay and their service is complete.
62 days. In view of the submission, IA1 of 22 allowed, delay of 62 days is condoned. Now 56.1, now steps 56.1. Respondent number 35 has unclaimed this notice. Service is held sufficient.
Ulditu, my lords, 32, if you honest for a minute to turn to page 28 of the writ
Do
appeal.
all those things, sir. You make a file, a memo and all those things.
Please.
Furnish the PF and all those things.
Hand summons to them, my lords, and
PB Learned Counsel for the petitioner seek time to take steps for the unserved response.
insofar as respond,
If they are already served in the writ, not represented, you seek dispensation.
please, and respondent number 34 and 40, my lords, they were represented by counsel. So if I can be permitted to serve a copy on the counsel and
Shri Achappa PB seeks permission to serve the counsel representing the unserved respondent before the writ petition, writ court.
please.
Full stop. In 56.2, same order, delay.
Oh, sir, 62 days.
225, Madam, IA1 of 22, same order, delay, condoned. IA1 of 22 allowed. Yes, date good.
18th April,
Highly obliged.
57.
My lord, I appear for the appellant, my lord.
I filed this application for 17B wages, my lord.
My lord, the respondent was a senior production executive managing 5 machines and 50 workmen. However, the labor court, my lord, held that he is a workman. We have challenged that. Now, in the meantime, my lord, because he was a senior production executive, since there was no vacancy at Mysore, we have transferred him to Uttarakhand. Now, the learned single judge has granted his salary is now offered to pay about 58,000 rupees, my lord, whereas he was drawing only 22,000 rupees at Mysore. Learned judge has granted 17B wages. Our contention is, my lord, once we have offered employment to him at Uttarakhand because of there is no vacancy at Mysore, since he is a senior production executive.
For modification, sir.
My lords, this is not a transfer, my lords. They have reinstated at Uttarakhand instead of reinstating me at Mysore.
There is no vacancy
My
at
lords, the
Mysore.
Honorable Supreme Court clearly says that reinstatement means reinstall. My lords, I may be permitted to place a judgment of Supreme Court, my lords.
He's filing IA for vacate.
He's filing.
No, this Honorable Court has granted a status quo. That while granting the status quo order, single judge's order has not been stayed. Hence, I am filed the application for 17B wages during pendency of the writ petition.
But they say you are offered some employment somewhere.
Yes. Employment at by Mysore, my lords. Because it's a reinstatement.
Posted them their branch in Uttarakhand.
The Supreme Court clearly says, my lords.
Answer is they have to give me posting.
He is a senior production executive who had one promotion. He was never in the cadre of workman at all, my lord. He was in the officer cadre throughout.
Those are all answered by the Labor Court.
That's right. Wrongly answered.
My lords, at para 21 and 22 of the judgment, my lords, the Supreme Court clearly says,
At Dipali Gundu, we are aware.
yes, my lords,
That is
exactly,
enough.
my lords.
He sat down for hearing.
Yes. Lord, during pendency, some relief, my lords,
What will?
because 17B, at least during pendency, I am out of employment for almost 8-10 years, my lords.
Along with the main appeal will
We will
consider.
consider.
Along with the main proceeding will consider.
My lords,
Along with the main appeal will consider.
short date may be given, my lords.
Short date first week of April.
Yes, my lords.
Representation not
Much obliged.
posted for you.
Number 58. The Sanjeev BL.
It would be taken up next week, my lord.
Next week, all
Yeah.
next week.
Learned counsel for the appellant. Next week.
59, I'm for the complainant, my lord. 59 to 62.
59 to 62.
Yes, my lord. But petitioners are the grandfathers of the land losing.
Sunil Kumar, they are all content. Notice. Heard Sunil Kumar Patel, counsel for the complainant, the notice.
Please.
Here takes notice for the pro forma respect. 59 to 67.
5th April. Much obliged.
Never there is a separate idea.
63.
Lord, I appear for the appellant, my lord. My lord, this is an appeal of the state government. My lord, wherein the respondent number 1, while registering his general power of attorney, pays stamp duty, my lord. At the time of execution of the sale deed, my lord, the stamp duty is not adjusted. My lord, so he seeks for refund. My lord, the appellants refuse to grant him refund.
Notice,
Sorry, may I make one submission?
delay is there. When once, then you as per.
So notice in both. Delay as well as.
Both.
Both.
Notice means both. On IA and.
15th April, seal number 64.
I appear for the
Surrender
appellants, my lord. My lord, this is a public interest litigation challenging Annexure B, which is the order of the DC directing the Kalburgi Urban Development Authority, which is respondent number 3, to allot the CA sites
interest, madam.
My lord, if my lords may see Annexure A, which is the plan sanctioned by the authority. Annexure A at page number 24, my lord.
Who are you?
I am the Society of Residents of the Layout, my lord.
Private interest.
No, my lord, this is public interest. If my lords may permit me to make submission. My lord, at Annexure A, there are 3 CA sites which are allotted for dispensary, post office, and primary school. Specifically, it has been stated that it is for that purpose. Now, these CA sites have been allotted to respondent number 5, all the 3 CA sites, my lord. Annexure A at page number 24, my lord. The 3 sites just above the park, my lord. It states that it is for dispensary, post office, and primary school.
Cannot identify that in the sketch. It should be in the separate order. You produce the relevant document.
My lord, it is written.
That is not correct.
My lord, it is clearly written there that it is for dispensary, post office, and primary school, my lord.
You are telling that we cannot decide on that basis. You should produce relevant records, that is, these are the sites are reserved for the resolutions of the committee and the Gulbarga Urban Development Authority.
Very well, my lord. I'll
Next
procure
day
the.
Cannot be treated.
My lord, I am pressing for a stay in the matter. My lords, may I be permitted to produce the judgment of the Supreme Court with this respect, my lord?
First,
My lord, already.
improve your pleadings, then we'll see.
My lord, let there be a stay in the matter, because otherwise the whole purpose of filing this petition will be defeated, my lord.
You should already expressed there is no public interest. If you want order, we will dismiss your petition. Or
No,
we are asking you to improve the.
Improve your pleadings, and whatever you want to produce additionally, produce.
Very well. May there be a subject to order at least. My lords, may I be permitted to at least show this judgment on the point?
We are not satisfied at this stage with your petition and the prayer.
Your pleadings itself saying no public interest. What is then what you will going to improve with that judgment? You can't improve the case by releasing a judgment.
My lord, there is public interest in this matter because.
Put up your facts properly, then we'll consider. If at all it is liable, if at all it deserves to be considered. Put up your facts properly.
Please.
Yes.
My lord, date may be fixed in the matter.
Date they will be
2 weeks.
2 weeks.
1st of April. Number 65. GA second Degoda. For respondent number 4, ma'am.
Interim order already granted.
In this case, one more appeal, writ appeal 360 of 2024, filed against, it's a common order made in 3 writ petitions.
We will take this writ appeal to 360, sir.
Yes, 360 of
The action for
2024.
filing those petitions are different, ma'am.
Common order.
And it is a common order that has been clubbed together and common order has been made.
Common order.
Thank you.
Then you can take order, submission note. So submits that writ appeal 360/24 has also arisen out of the common order. Submission placed on record, call this writ appeal along with WA 360 of 24.
Interim order is granted, my lord, already.
Yes, yes.
That may be continued.
Order extended.
The date may be fixed, my lord, for you.
Yes.
We are giving date in each and every case. ಏನ್ರಿ ನಿಮ್ಗೆ ಹೇಳಿದ್ರೆ ಅರ್ಥ ಆಗೋದಿಲ್ವಾ? Why
18th April,
such submission?
November 66,
It is a request to all the learned advocates not to ask for the date. We are only giving the dates. If you want early date, only make such subject. Everybody asking, give the date. What is this?
Number 66, Mr. Madhukar M. Deshpande.
For the appellant, my lord. This matter is already connected with writ appeal 163 of 2024, and that is listed on 22nd of this month.
22nd. Shri Madhukar, learned counsel for the, you are for appellant, sir?
Appellant, my lord.
Learned counsel for the appellant submit that the connected writ appeal.
163 of 2024.
4 is posted on 22nd March. Post this along with 163/22.
Obliged.
67, Mr. Varun R.R.
Lords, I appear for the complainant. Lords, it's contempt petition, my lords. Lords, order that is not followed is, my lords.
For the complainant not passed the IA 1 of 24. IA 1 of,
Please.
IA 1 of 24 dismissed.
Please.
Full stop. GA takes notice to the pro forma, notice to IA 1 and 8.
5th of April.
Obliged.
Number 68,
I appear for the appellant. The case, my lord, the respondent number 1 to 3, they were in the cadre of, my lord, stenographers. Next promotional avenue for them is, my lord, to the senior assistant, where they are required to, my lord, undergo 1 year work as an assistant.
We will take notice, sir, from
assistant.
all respondent number 1 to 3.
Therefore, my lord, there is a 1 day delay in filing appeal. But no, learned single judges order, my lord, resulted in, my lord, excess of promotion to the cadres.
Sir, thumb slip code so and so takes notice to the R1 to 3, 5 to 12. Government advocate takes notice to the 4th respondent. Full stop. Still for the respondents have no objection on IA 2/24. Full stop. Submission placed on record, IA 2/24 is allowed. Delay of 1 day is controlled. Post for preliminary hearing.
Till then, my lord, till then, my lord, because the
Based on the memo, my lord, which was filed, my lord, after having a discussion.
You have filed any contempt, sir?
No.
You have not filed.
please,
Yes.
18th of April.
let the respondent number 4, my lord,
Senior.
let respondent number 4 is the state government, my lord, the GA may be directed to take.
Yes, I've taken note.
Already directed, ನೀವು ನಮ್ಮ ಡಿಕ್ಟೇಷನ್ ಕೇಳಿಸ್ಕೊಳ್ಳಿಲ್ಲ.
Please.
Number 69.
Appellate.
VS Nayak. 69. VS Nayak.
Yes, GA takes notice to the pro forma respondent, notice to A1.
5th of April. Number 70. CSP total.
Please.
I appear for the respondent number 2 and 3. My lord, learned senior counsel Sri T.R. Ravi Shankar is engaged in this matter. He's on his legs is court hall number 23. The matter may be taken up on any other date, man.
R2 and R3, there are private respondents.
I appear for R2 and R3, man.
You take both R2 and R.
ಹೌದು ಎರಡಕ್ಕೂ KV.
Anirudh Kulkarni takes notice for R2 and R3. Then who is R1? Chief.
R1 is the BBMP.
BBMP Chief Commissioner.
BBMP. Where is the panel lawyers?
NK Ramesh.
NK Ramesh. NR Jagdish. Shri NR Jagdish is requested to take notice to R1. Then we'll post for Mr. Let the senior counsel talk.
18th April.
Post for hearing on IA 1 of 24, 1 and 2 of 20.
Number 71. The Manasi Kumar.
I appear for the second respondent.
I appear for the appellant's counsel in this case, my lord. But the appellant, my lords, was.
Right, main. It's a short accommodation in this case, man.
R1, sir.
Please come. Was the appellant in this case, my lords, was appointed as.
This appointment of the chairman of this commission is under question. Now, before the single judge, my lord, 2.5 years are over. Now, 1.5 years is remaining. The lordship can hear the matter itself, my lord. Learned single judge has
What,
held
what
that
has
he
happened
is
in this
not.
case, my lords, is the appointment as of the appellant as chairperson of the National Commission for Homeopathy was challenged by the contesting private respondent. That petition was pending for about 2 years, my lord. There was no interim order. Eventually, my lords, the original records were called for, which included an opinion of the Ministry of Ayush, which subsequently got approved by the Cabinet of the Union of India. And my appointment happened. There, my lords, the learned single judge has not found fault with the selection procedure that was followed, but has found a fault in the statutory, the fulfillment of certain statutory requirements.
Now it is already 3 years over, sir.
Now 1.5 years are there.
Up to 4th of July, my lords.
Now 2.5 years are over. Term is 4 years.
Now it's appointment.
No, it's also, what's happening right now, Malas, is now of course, that would not lie in my mouth, rather lie more in the mouth of the Union of India, but the commission is functioning without a chairperson. The union also has preferred an appeal.
Lord, we have also preferred an appeal.
And where is the number, sir?
WA 285 of 2024. If your lordship may kindly see, my lord,
285.
please, my lord.
Then we will take this and we will fix up a date.
My lord, this is straight away covered by the judgment of the Honorable Apex Court, my lord, where the selection process for a public employment cannot be interfered by the court is what is told, my lord. If your lordship may kindly see, my lord.
He is not eligible at all.
Lord, for the eligibility, my lord, I'll make my submissions on that, my lord.
Then we will take it, we will fix up one date and we will take it up and.
Lord, till then, my lord, till then petitioner may be permitted, my lord, because it cannot be vacant, my lord.
I have not filed
Now it is
contempt
by virtue
petition.
of the order of the learned single judge
Correct,
now
Mr.
kept vacant.
Please,
Yes,
my lord.
Malas. And now what's happening is the academic year is coming to an end.
Functioning,
Lot of
I have
Many
approvals
other
have to
things,
be.
contempt
Lord,
petition,
if your
government
lordship may
is
kindly see,
supporting
my
it.
lord, there are many things to be done in the.
It was a writ of quo warranto? No.
No, it was a
Whether it is
certiorari, Malas, to quash the appointment order.
Lord, the Apex Court says, my lord,
Because he
that
is a-
the interference of the search committee cannot be looked into, cannot be gone into in the judicial review.
Then he is not eligible according to the rules. My learned friend, my lord, is saying
If
that
your lordship
even if
may
he is
kindly
not
see, my
eligible,
lord,
court has no power. In fact, the
What is
rules
the
say.
interim order before the learned single judge, sir?
There was no interim order.
No
Malas.
interim
We
order.
we were permitted to function.
Lord, he did not challenge for 2 years.
No, I challenged
he
it.
challenged it, there was
But
no
court
interim order at all.
decided after 2 years. I challenged it, I could not get an interim order. That's a different issue. You cannot put the blame
Lord,
on me.
the
Lord, what
post-
I would request is, once stay order is granted, my lord, matter will not be heard. That's why, my lord, you
Lord,
lord, I have not filed contempt petition. Government is supporting, even then, even today is continuing in office. Kindly fix up a date, I have not precipitated the matter.
cannot be kept vacant.
Where is it kept
The-
vacant? You
now,
are
by
allowing it
virtue
to
of the order,
continue.
my lord, by virtue of the order, let him be permitted to.
We'll hear the.
285 date, is it any date given?
No, my lord.
What is your good name? Mansi Kumar?
No,
You- sorry.
madam is mindful.
We'll go. Yes.
So pardon me since I
DST.
am getting acquainted.
No, of course, no.
Yes.
The DST submit that the Union of India has also filed appeal, WA 285/2020. Good stop. We will go to appears for the appellant, Shri Ashok Karnali for the respondent number 1. Take this appeal along with 285/24. Good stop by consent, post date.
Earliest possible date, Malas, because I think all the parties are ready.
I have no objection.
Subject to your lordship's convenience, the earliest
Consent
possible.
of both. You have the matter of record little urgency by consent of the.
Even
Last week of March. Early, second,
subject to, I'm here.
26th of March.
26.
26th.
Very well.
If any defects and everything, please cure there, sir, DST.
Please, my lord.
urgency in the rest of the matter, then otherwise.
My lord, may I make one
So item
submission, my lord?
number 1. Mantha Reddy G. Senate Council for the appellant has filed a memo for withdrawal of the memo reads as follows. The memo accepted, permission accorded, appeals dismissed, it has withdrawn. Abhishek Malipatil. Serial number 7 withdrawn.
My apologies.
Memo for withdrawal.
My lords, it's being opposed, my lord. That is why, my lord, it's still pending. It's being opposed.
Then we will take it up. Only one.
There's only one IA that needs to be heard, my lords. Otherwise, all other issues have become infructuous. We'll address that, my lords, on many other.
This one.
To my lords, I
Please
place it
give
before
all
your
the
lordships.
synopsis, sir.
And my lords, address only that issue.
The rest of the matters all will be, date will be given, sir. Any urgency here, you pass on your tips along with the dates. We
78.
accommodate.
Interim order may kind.
If not, all the matters will be given date.
There are 78.
One
Connected
submission, my
matters
lord.
are coming day after 7th, my lord.
List number 2,
I pray your lordship take
lord.
up with connected matters.
Give the.
My
This
lords,
week
one
you don't
submission, my
take-
lord.
Request is that don't take any dates, please take after next week. Otherwise it will not reach. We want all the matters to be reached.
My lord, one submission, my lord. List number 2, my lord, serial number 2, my lord.
Hear it, please, sir.
My lord, this matter was posted 2 times, my lord. It has not yet reached, my lord. May I request your lordship to direct the court officer to post.
2024 matter, it will come for preliminary hearing, sir, in this. Don't worry.
Pardon, my lord.
List all barutte.
Much obliged.
Your lordships leave serial number 80. A similar matter is coming up on 7th, day after tomorrow.
It will be given on the similar matters are there, give the same date and post along.
Read.
Give the number.
End it. I'll.
78 also similar. to 70.
We'll see, just let it be.
Yeah,
Seven,
Connected is there, give the slip.
I'll give the number.